Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today we are talking... What is my... Oh my goodness. So much hair! Ah! I don't know what to do with it anymore. Today we are talking about Keemstar and his ongoing lawsuit with Romeo Lacoste. Romeo Lacoste, Romeo, where art thou, Filings, oh Romeo? We've got Nico Lacoste has sued. If you don't remember, this guy has sued Keemstar from Drama Alert for reporting that Romeo was carrying out conversations of a sexual nature with girls as young as 15 years old. He then proceeded to have an alleged girl who was claiming at the time of the conversation, not with Keemstar, but with Romeo, to have been 15 years old and sharing some information from those. He then went on Keemstar's show to defend himself against these salacious allegations and went ahead and admitted to talking to girls that he knew were not quite 18, and then because of that horrific defamation has sued Keemstar, and in the lawsuit admitted to doing what Keemstar said he did in the filing, having a conversation with a girl who was under 18 that was sexually explicit. So that's how we got here. That's where this started. I hope that helps people understand the backstory to this. Oh my God. Every time I say it, it still makes me smile, because it's still stupid. I don't know what else to do, right? Like, it's baffling that you would bring a suit like this, but it's understandable. Okay? It's understandable to bring suit against someone who has accused you of doing something that ruined your career. If you didn't do it, and if you don't then admit to doing it in the lawsuit that you're filing, those are two big no's. Big, like, not like mine, like the N-O no's, right? Not the grifter no's. Those are two big negative points on your plan, and I would strongly recommend not doing it. What? Oh no, the hair. It's the worst choice I've ever made. I'm gonna go find a Minecraft server immediately. You'll never see me again. But that being said, he goes ahead, he files a lawsuit. Okay, makes his weird admissions. Okay. Keemstar and his counsel, they get I believe they got a little bit of an extension. Asked for it, got the extension to consider their answer. They filed a motion to strike. A motion to strike the entire pleading of Romeo. All right, so here's what happens. If you are suing someone, you file a complaint, or, you're pleading. That's your complaint, your petition, depends on the forum you're in and what type of court, but we'll call it a civil complaint. You file your civil complaint, that's your pleading. Now, Keemstar's lawyer filed a motion to strike the entire complaint. All right, so that, if successful, removes the civil petition for the lawsuit. And if that happens, there is no lawsuit. It can't occur at that point because there's no claim for the court to hear, and the court will have to dismiss the claim. Now, there's a couple ways around this. Of course, you can oppose that motion, and if you're successful, and it's kind of weighted in your favor, but if you're successful, then your complaint stands and you get to move on to the next part of the case. Or you can amend your pleading sometimes to cure the alleged defects. You say, oh, you didn't provide this information, and it's like, oh, yeah, well, I can cure that because I actually have that information. We can fix it, and if you fix it, then the case could possibly proceed. Now, a judge could determine that there are defects that are beyond the possibility of amendment, and if that's the case, then you don't get to amend and your suit gets dismissed. But if you don't amend your pleadings, and if you don't win on your motion, then your case will likely be dismissed as you didn't have a claim. And so that's the goal here. Now, California is an anti-SLAPP state. I'm just giving you a bunch of background here because this is all very important to how much rests on this particular transaction. I want to how do I say this? I want to impose upon you the gravity, the absolute gravity of what is taking place right now. How important this part of the case is. If you don't overcome the motion to strike, if your case is then dismissed and you lose, California, being an anti-SLAPP state, has this provision called a slap back. Now, some states kind of integrate this. Texas integrates the whole slapback process into its anti-SLAPP, or the Texas Citizens Participation Act. They integrate them. But what a slapback is you get sued. You claim it as frivolous. You then get the case dismissed based on its frivolity. Then you file a countersuit or a slapback lawsuit. And that's where you get to potentially recover damages for the fact that someone basically filed a frivolous lawsuit to suppress your free speech. That's when you get to go after them for money for making you deal with the court system when you shouldn't have had to. So if you don't get dismissed, if you go to a jury trial, you're probably not going to get a slapback, right? And even if you get past the initial dismissal stages and things get dismissed later on for some other reason, probably not going to be a slapback. It's really that the court has dismissed the action and found it frivolous to the point where they say, to where you need to recover for it. That's what's going on here. If Romeo loses now, at this stage, from a dismissal for having his entire pleading struck as frivolous, he stands to not only lose this case, but be extremely vulnerable to a slapback case. Now, I don't know what Keemstar has planned for Romeo. I don't know, obviously. I've not talked to Keem about this. Would love to talk to him about it, but I have a feeling Keem probably doesn't want to talk too much about these legal actions until, the case is over. So we'll just have to hold our breath on that one, I'm guessing. But that being said, I have no idea. But Romeo has been a successful tattoo artist and a successful YouTuber, and quite possibly has something to take, which is the most dangerous place to be when you're involved in a lawsuit, is to have something the other person can take, like money, assets, anything like that. If he's got money to pay, then you can go after him for that, and that could be very, very damaging. He's also got a lot to lose because he's a successful business person and a successful YouTuber, and now he's kind of looking like a successful pedophile. And that is a very big image problem. It's luckily in his tattoo business, he's technically only supposed to work with people who are 18 and older. Although we're not quite sure if that stopped him at this point. But anyway, it's an image problem. It could be a money problem. And all of this really comes into play in this lawsuit at this point. Okay, so why is all of this important? Why is all of this important? Romeo's lawyer filed his paperwork incorrectly on what? Let me get the actual timeline up. I want to do that because I want to make sure I report this accurately. Getting the timeline actual. We'll pull it up right now. Just a second. All right. So he filed a response on the 11th of May. Now this is going to come into play. Very important. The 11th of May is an important date. He filed a response on the 11th of May and served it. Okay. On the 12th of May, the judge looked at it and said, nah, fam, strikes it. Gone. Not legally operative. Unimportant. It's now just, it's a footnote. They filed something. The court is not going to consider it. That was his response. Because you don't file a response to this type of motion. You file an opposition to this motion. That's the rules of the court. Also, there was a section that was single-spaced that was supposed to be double-spaced according to the local rules of the Central District of California Federal Court. If you don't follow the formatting rules, the courts can allow you, to proceed. Like, they can waive their own rules. But they can also not allow you to proceed. They can enforce that rule. So judge says, nope, you violated two rules here. It's mistitled and you failed to properly format your document. So he gives them until the 13th at noon to go ahead and refile the document with the correct heading and the fixed spacing. All right. So does Romeo file, or well, Romeo's lawyer, Raul Severo, does he actually file it by noon on May 13th? No. That would have made sense because a judge told him you need to file this by this time. And he then didn't do that. Instead, he filed it the next day. But not only did he file it the next day, he filed it, but didn't fix the spacing issue. So he only dealt with, well, he didn't deal with either of the two issues. Well, he dealt with the opposition being properly labeled. He labeled it an opposition. That was great. But then he created a new problem by filing late, and then another, and without explanation. And then he created another new problem by not fixing, or reignited the old problem by not fixing the spacing. So again, a judge has informed you. I can't stress this enough. Not only has a judge informed you that you must follow the rules, he struck your document. He said your document is in violation of the rules and therefore invalid. You must do this to fix it. And he failed on both of them in his subsequent submission. So the judge struck it again on the 15th, although it was actually, it was late in the day on the 15th, I believe, that he struck it again. And he entered the ruling came in today, this morning, or that it was entered into the system this morning. And so people could see that he did strike it again. Well, now Raul Severo, Romeo's lawyer, has filed an objection and a declaration talking about why he screwed up the filing. And we're gonna, I think maybe it bears looking at that document specifically. Oh, great. Hold on. Let me pull it up. All right. We'll pull this up in just a second. We'll go through his reasons, because remember I said that May 11th date was important, that he filed the thing on the 11th. Hold on. And then we're going to look at his objection, and we're going to ultimately look at the filing as well. But we'll go through all of it, because, you know, that's what we're here for. That's what we're here for. So here we go. Here's his objection. I'm pulling this one down too. But why this all matters. You've had a judge tell you exactly what you need to do. You know, if you don't get this done, you lose the case. And then he didn't do it correctly twice. It's terrible. Terrible planning. Now he's going to be at the mercy of the judge to say, to go through his declaration here and his explanation. Let's pull that up. Got that here. He's going to be at the mercy of the judge to accept this excuse. And if the judge doesn't accept this excuse, he has no opposition to the motion, which means that the motion is unopposed, which means that if the motion is sufficient on its own, unopposed, then they will strike the pleading and Keemstar will win. And there won't be anything they can do about it. And then Keemstar can do whatever he wants with a slapback sort of motion. That is a bad place to be. Look, every law firm, every lawyer is going to make a mistake somewhere. They're going to miss something at some point. Something's going to go wrong. All of these things can happen. Absolutely. But having them all go wrong right now at a critical juncture of an already really tenuous case it's the worst set of circumstances that Romeo Lacoste could find himself in. And maybe it's proof that there is a God, or maybe it's proof. Maybe the feds did it because they've been tracking him. I don't know. That's a joke, by the way. Don't take that seriously. That's entirely a joke. But it's the worst situation. You couldn't ask for it to be this bad. All right. Okay. Let me get these two chats in, and then we'll get going. Skaki Onsai says absolute gravity. I don't think we were talking about Stacey Abrams tonight. Hashtag it's raining men. By the way, Oregon Circuit Court judge tells Oregon Governor Brown to bleep off 8 hours later, emergency stay at home extension to hear the case. Hashtag Oregon be free. Yeah. That's pretty amazing. The judge in Oregon put a temporary injunction up against the governor's stay-at-home order and says that it violates its citizens' rights. I mean, who would have thought, right? Like locking down an entire state might violate some principles of the Constitution. I don't know if anyone out there was saying it, but somebody, I guess, was. I mean, I never have suggested that that's happened. I mean, sure, Wisconsin's law was struck completely, or their executive orders were struck and called unconstitutional, had to roll back immediately. Now Oregon has a temporary injunction on the imposition of the order. And because the judge finds it likely that they will succeed on the merits of the case and defeat the governor and his abuse of power for directly going against the rules that are in place for these sorts of things. Yeah, again, who knew? I hope more states sue and we start getting some precedent about what the extents of emergency orders are. The Constitution doesn't stop for a virus. It just doesn't. So I know that bothers some people. If you don't like that, great. Go lobby Congress to change the Constitution, or your state Congress to change the Constitution. Go lobby for the changes that you want. But people never want to do that. They just want to have it their way. Okay, Stacy Dealman says, Nick, are you going to talk about Ron's YouTube interview tomorrow or sometime soon? Maybe. I don't know. I guess I could talk about it soon. Not tonight, though. Not tonight. Let me see what's going on tomorrow, and maybe I'll do it then. I don't know. We'll see. I've got another doozy of a case where to talk about soon. Just this is off topic, but an old lady has sued all of the gay people. All of them. Every gay person has been sued by an old lady. She filed a document. It's like, plaintiff, me. Defendant, the gays. Can you imagine? So that's got to be covered. I think that needs to happen. So that's I'll be talking about that very soon as well. Maybe, it all depends. And yes, Ron's got Kiwi Farms conversations, all of that. We're going to work that into a nice little bundle and see what we can do. Fran Mataraki says, it's Romeo, the man with the plan to make an underage hymen expand Lacoste. Oh, come on. No, Fran. No. To be fair, we don't know if it's a hymen or a jawbone, but that was a very uncouth joke. Very uncouth. So, okay. I definitely don't encourage people making fun of Romeo Lacoste for admitting to having sexually charged conversations with minors. That would be terrible if people do that. The jokes. I cannot believe you unruly audience. I, Raul J. Severo, declare as follows. I'm an attorney at law, duly licensed to practice before all courts in the state of California and a member of the bar of this court and the Ninth Circuit Court of Appeals. Submit this declaration in support of a request for an order permitting the filing of plaintiff's opposition to defendant's special motion to strike complaint. I recently moved our law offices on May 8th to 11th, 2020, and had new internet service installed on May 11th, 2020. Our offices suffered an internet outage due to problems with AT&T's computers, failure to recognize the installed network, and our firm's emails were not updated in time for me to meet the court's order, setting a deadline of 12 o'clock noon on May 13th, 2020 for the filing of a corrected opposition to defendant's special motion to strike complaint. So, even though he had internet as of the 11th, like he had it, we know he had internet on the 11th. He filed the document on the 11th. So let's follow that. The 8th to the 11th was the time they got to the new office. Okay? So then on the 11th, the internet was installed and presumably functioning because that's when he went ahead and filed. But he's now claiming that AT&T's computers failed to recognize the installed network. I don't know what tech issue this is. He doesn't really explain what AT&T's computers recognition of the network is. Does he list his email address as severolegal.com? I mean, his internet's functioning. Does he just not have data downward? Like, he could only upload? Is that what he's... It's not really clear. Now, maybe his internet's on an Exchange server that's hosted off-site and didn't recognize the new network. I don't know. Like, I honestly am not sure what he's saying here besides tech speak, hope, judge, not get. That's about it. I don't know. Does he not have a... He must not be a Blizzard fan, right? Like, because if you're a Blizzard fan, you have a phone. Do you not have phones in your entire firm? No one at the firm got a push email? Like, not anybody? Anywhere? I don't know. I can't imagine this. Your Honor, I was trying to use Internet Explorer. Yes. Okay. On May 15th, 2020, this court ordered the aforesaid opposition stricken pursuant to Local Rule 712. I respectfully request that this court issue an order allowing the tardy filing of the opposition to the special motion to strike complaint for the reasons set forth herein, which were outside my control. I declare under penalty of perjury that the foregoing is true and correct. Executed at Glendale, California on the 18th day of May, 2020. So, here's the problem. You clearly got it on the 14th. Right? Like, we can all figure out that by the 14th at the latest, he had this because here it is. This was filed 5/14. That's at the latest. He had it then. I don't know what time on 5/14, but this was filed before close of business because it did show up in the filing system on 5/14. All right? Why didn't you explain why your document is over 24 hours late when you filed it? Because the judge doesn't issue this strike until the 15th, right here, 5/15. This is when he strikes it. And then on 5/18 is when he files this. I mean, I don't know what to say here other than if you are submitting something late to the court, you better have your apology loaded in the filing. Your letter of explanation. Here's what happened, Your Honor. By the way, here's proof that our email didn't come in. Here is an affidavit by the tech support in our office. Here is whatever you can muster at this stage of the case to show that you didn't just fall asleep watching reruns of Baywatch or whatever, right? Like, it's frustrating because now, and will the court accept this? Maybe. They can. They might not. We don't know. We won't know on this for a little while, but we'll have to see. But here is plaintiff Nico Lacoste, opposition to defendant's special motion to strike complaint. I don't know if he's got the objection in here. I assume not. Let's see. Here's the pleading is 23 pages. Or the first opposition is 23 pages and this one's 24, but that's probably just from the double spacing. So we'll have to just look at it. I don't know if he's got his objection in here. It's labeled an objection in the filing. Doesn't seem to actually address the objection at all. So that'll be interesting. We're going to get into this in just a second. Yeah, there's no actual objection. He called it an objection. This is another problem. What he should do is he should have actually filed an objection to the strike. Preserve the objection. Just in case you want to try and appeal the objection is unfair or get a writ of mandamus or whatever. You got to try and preserve it. Okay. Mithrin Emrys says, wait, did she file against Tegaze or the Gestapo? Because there's a distinction there. No, my understanding is she is suing all of the gays. Mainly soy content and use of hair coloring, but still. Also, how quickly is Romeo going to lose this case? Because, damn. I don't know. I have a strong suspicion that he's going to lose this case at some point. The judge might, I mean, we're going to read his opposition and see what arguments he has right now. If the judge even considers this, he could still lose on this motion. because his complaint is a huge problem. His complaint says he's defaming me by saying what I did, and here's what I did, and it's that. That's a big issue. And in their motion to strike, they included, they included the evidence for all of these things. Now, it'll be up to the judge, of course, and it'll be up to their arguments here if the judge even allows it. So we're going to go ahead and get into this in just a second. I'm going to, excuse me, I'm going to finish this Highland Park 18 tonight, which is going to be a joyous experience. I don't know if you guys like Highland Park, but it's one I would recommend. We've got a small glass of whiskey. Let's get started. Okay. March 10th, 2020. Plaintiff Romeo Lacoste, doing business as a California Dream Tattoo, filed a complaint for damages alleging tortious interference with contractual relations and interference with prospective economic advantage against defendant Daniel Keemstar Keem, doing business as Drama Alert. Now, importantly, they don't sue for defamation, but the underlying tortious idea is defamatory statements. They are careful to try and not say defamation. Wisdom of this, up in the air. I mean, this whole lawsuit is bad. But I want to muse on this for just a second. The wisdom of this is, 6 of one, half dozen of the other. If you file defamation, it becomes very obvious that you're trying to sue someone for saying something truthful about you. Because you admit that it's true in your damn pleading. Okay? Like, that's the key that we've got to keep in mind. When I'm saying it's true, it's because he says it's true in his own filing. This is what I did, and it just looks exactly like what he's accusing Keemstar of saying. Okay, so that is a problem. But if you put defamation in there, it becomes even more apparent. So if you leave defamation out and just try to go with the tortious interference with contracts and prospective business advantage, you don't have the defamation, so I guess you're trying to pretend that you're not suing over a lie. You're just suing about the release of some sort of information. Most states, truth is an absolute defense to tortious interference. When the tortious interference is a statement. If that statement is true, in most states, that's a defense. I didn't say anything false. I didn't try to interfere with his business in any way that's not permitted, because it's true. Now, the other problems that he has with this is tortious interference with contract tends to involve the specific targeting of a specific contract or multiple specific contracts that Keemstar must know exist. Like, okay, he's got a deal with, HGTV for tattooing someone's walls. I don't know what this weirdo does, but so if he had a specific contract and then Keemstar called up that specific business and said, hey, by the way, this pedo talks to little girls, then you've at least got him trying to, and you should stop doing business with him, then you've at least got an argument that he's targeting a specific contract, which I would rather contracts be targeted than minors, but he's at least targeting a specific contract, right? Like that's an idea we can coalesce around. He hasn't produced any evidence of that at all. He's merely stating that this has impacted his contracts, and that's typically not sufficient for tortious interference with existing contracts. Now, tortious interference with prospective business relations is a little more expansive. It doesn't necessarily, you don't necessarily have to allege a specific contract that they interfered with, more that they knew there would be contracts and they would go and that the actions they were taking, the underlying tortious act, would be damaging to prospective contracts. Because you can't know a contract exists if a contract doesn't actually exist, right? So this is the idea. But the higher bar for prospective economic advantage or prospective business relations is that there has to be an underlying tortious act to support that. It's an element of that tortious interference. Like, tortious interference with a contract is its own tortious action, independent of anything else. Tortious interference with business prospects or prospective economic advantage, that requires an extra underlying tort, and they don't have one in this lawsuit because they left out defamation, but they're trying to imply it. So anyway, breaking all this back down into the other problem, defamation has a high payout on the top end. If you win a defamation suit against someone with means, you can get punitive damages, you can get compensatory damages that are very, very high. If you win a tortious interference contract, you really are limited to the amount of actual loss from the specific contract that was interfered with. So defamation claim can reach into the millions of dollars if millions of potential damage was done. Calling someone a pedophile who's not a pedophile and specifically accusing them of illicit acts with minors, if they didn't do it, is highly, highly damaging on its own. May even be defamation per se, depending on exactly what was said. And those presumed damages and then actual damages can go really high. Plus you can get punitive damages on top of that. Tortious interference with contracts and prospective economic advantage don't have that typically. It's an actual damages sort of thing. Now they could try and get some extra damages, but the prospect is really low on that. It's much higher on defamation. So that's what I'm saying. Leaving out defamation goes two ways. I know I'm giving a lot of backstory, but this is a really interesting case, and it's kind of an object lesson in a lot of mistakes being made in the filing process that shouldn't be made. Like, this should not have occurred in this way, and certainly not when a lawyer who saved Moses from Pharaoh personally by intervening on his behalf. When a lawyer that old is around, these things should be part of, they shouldn't be a question, right? Like, this guy is not new. He's not making some newbie mistake. This is there's a whole lot of mistakes in this case. And this is just the structure of it is a mistake in and of itself. Mithran Emrys says, are they going for false light rather than defamation as the underlying claim? No. I mean, they could have, but they did not sue for false light or defamation. So on the face of a complaint, the second cause of action has to fail by itself. I know that is more about the implications of the statements rather than the statements themselves, but we glossed over it in torts too. Don't worry, they glossed over it more in this lawsuit. It's not even in there. Okay, so defendant Keemstar did not file an answer, but on May 1st, 2020, filed a motion to strike the complaint pursuant to California Code of Civil Procedure 425.16, California's anti-SLAPP statute, because the motion to strike fails to establish infringement on constitutionally protected speech and fails to show that plaintiff cannot succeed on the merits of his claim, the motion should be denied. Okay, so right away, these are Hail Marys, I'm telling you. Because the motion absolutely did both of those things by itself, but these are the two theories they're going with. I was kind of hoping they had more, but let's see what they put in their facts. Now, to be clear, this is a motion. So the judge is supposed to read all of the factual disputes in favor of the non-moving party. We've talked about this in the Vic Mignogna case and other cases, even though Chupp didn't really do that. But in the non-moving party gets the benefit of the doubt on disputed factual scenarios, and anything that they say that is undisputed is taken as true. Okay? So it's taken as true if they say it, and if it's disputed, it falls in their favor as well. That's how this goes. The problem is some of the statements in this case were made by Romeo himself. And that's not disputed factual, that will be the accepted factual reality. That he talked to a minor who was underage is going to be, having a sexually explicit discussion is not a disputed fact. Both parties agreed to it, and that is going to be critically damaging to this case. All right. Complaint outlines the facts giving rise to plaintiff's cause of action. Defendant's motion provides a factual summary and refers to exhibits which were lodged with the court. Defendant's statement of facts excludes important facts from the exhibit. Oh, okay, this is good. First, in his interview with plaintiff, defendant states that he just heard that a bunch of other clients have dropped out as a result of the allegations reported on Drama Alert. Okay. Second, in his interview with Mira, included as Exhibit 4, defendant states, okay, that's how popular he was, but after the story came out with him trying to hook up with underage girls, his career is finished. Nobody wants to get a tattoo from this guy for obvious reasons. Now, you have almost free reign to frame a factual narrative. Okay? I want to point this out. Again, mind-boggling lawyering going on. Raul Severo is playing 8D underwater, I don't know, suicide or something. I don't know what he's doing. Or else he's just bad at this. Really, really impermissible. Not like he's not a specialist. Like impermissibly bad at this. You have the opportunity in this section to frame the factual scenario in a way that is best for your client. And the way you choose is to point to only 2 statements and say that Keemstar said, lol, no one wants to work with this weirdo after the allegations came out, lol. That's it? That's it. Not Romeo Lacoste did not do the things Keemstar accused him of. Romeo Lacoste was ambushed in the interview. Romeo Lacoste was enticed or manipulated into giving admissions taken out of context that make it look like he was guilty of something that he wasn't guilty of doing at the time. He makes no actual admissions that the person was underage or that he had any knowledge of it. It's been twisted by Keemstar and defense counsel. This is what actually happened. Nothing but lol bro lost clients. That's it. Again, you get to write the story, and instead you write 2 sentences about losing clients. And again, Keemstar acknowledging after the fact, which they're going to try and twist into, look, Keemstar was intending to cause him damage. That's what they're alleging here, right? Keemstar did this intending to interfere with his business. But what they've provided are reactions to a factual scenario. That these allegations came out and you lost business. Not, I wanted you to lose business. Not a smoking gun from before the accusations came out with a DM on Discord where Keemstar's like, haha, I'm going after this prick Romeo Lacoste. Super pedo. We're going to make him lose all his business. Nothing like that. They don't have anything like that. Only after the fact assertions or observations or opinions about what has caused a decline in business, or merely a secondhand relay of what he heard. Who knows what Keemstar hears? Keemstar gets a ton of criticism for being a drama whore. His channel is Drama Alert. I mean, I hope you know why you're going to watch it. But he gets accused of that. And so you could certainly, as Keemstar, say, look, a lot of people tell me a lot of things. I'm a place people go to for drama. And I have heard that after the allegations, he lost business. Of course I heard that. Everybody heard that. Pretty simple. That's not, you have all of the, this is his whole fact section. The factual summary of the entire case. And this is what he puts out. Now, when you make your complaint, it's paragraph. It's very disjointed. It's not a great narrative strategy. It's this happens. Here's the law, and here's how we apply these paragraphs into the law. It's very mechanical. This is your chance. Your motion practice fact section is where you tell the story of the case. Judge, how can we make it clearer that this guy was doing tattoos on the likes of Ariana Grande and other stars, and now he's widely derided as a pedophile because of the lies of Keemstar? You have a chance to tell that story and you don't take it. Embarrassingly bad. No, Andrew, not yet. Magnus Borson says, just finished my 6th novel and celebrating with a drink. Your streams have been a great help to my sanity through this whole affair. Cheers. Writing your 6th novel? Oh my goodness, buddy. Congrats. Okay. Defendant's motion to strike the complaint should be denied because plaintiff's claim does not violate California's anti-SLAPP statute. Oh, but it does. I mean, I don't know exactly what the argument is yet. Let's take a look. California's Code of Civil Procedure, section 425.16, subdivision B1, holds that, quote, a cause of action against a person arising from any act of that person in furtherance of the person's right to petition or free speech under the U.S. Constitution or the California Constitution in connection with a public issue shall be subject to a special motion to strike unless the court determines that the plaintiff has established there's a probability that the plaintiff will prevail in the claim. California's anti-SLAPP statute employs a 2-part test. To succeed on their anti-SLAPP motion, defendants had to show both that their acts arose from behavior aimed at furthering their First Amendment speech rights, and also that plaintiffs had shown no probability of success in their claims. To succeed on an anti-SLAPP motion to strike, the defendant must first show that an act in furtherance of protected expression is being challenged. The defendant must demonstrate activity qualifying for protection, and comparing that protected activity against the complaint, it must also demonstrate that the activity supplies one or more elements of a plaintiff's claims. Defendant has failed to establish that the challenged statements arise from protected activity because the statements do not involve an issue of public importance. Now, here's where they're wrong. Because defendant's motion fails to satisfy this initial requirement, this court need not consider whether plaintiff would ultimately succeed in his claim. So we're on page 3. Defendant fails to establish the statements satisfy the public interest test. All right. So here they're going to attack and try and argue whether or not a self-described popular tattoo artist being involved in sexually explicit relationships with minors is a public interest. Let's see how they do. Oh my goodness. Okay, defendant makes the conclusory statement that the subject matter of the YouTube videos at issue is undeniably a matter of public interest. I will say one thing. That is a conclusory statement. That is true. I'm pretty sure they went ahead and justified that following, but let's go through. Defendant is incorrect. In the context of the anti-SLAPP statute, public interest includes private conduct that impacts a broad segment of society and or that affects a community in a manner similar to that of a government entity. The California Supreme Court has established a 2-part test to determine whether a controversy presents an issue of public interest. First, we ask what public issue or issue of public interest the speech in question implicates, a question we answer by looking to the content of the speech. Second, we ask what functional relationship exists between the speech and the public conversation about some matter of public interest. It is at the latter stage that the context proves useful. It is not enough for the statement to involve a subject of public interest, that the statement must in some manner itself contribute to the public debate. Citing Wilson, even where speech involved a topic of public interest, it was not protected here. Here, it related was not connected to any public issue. I think they misquoted this. Even where speech involved a topic of public interest, It was not protected here. It related, was not connected to any public issue. I don't imagine that that's an exact quote from the text, because maybe they mean where. It's not protected where it related was. That's not English. It's not, those aren't words that make sense. So, okay. In determining whether speech involves public interest, the court should consider a, quote, a few guiding principles. First, public interest does not equate with mere curiosity. Second, a matter of public interest should be something of concern to a substantial number of people. Now, Romeo Lacoste admittedly had like 1 million YouTube subscribers. That's a substantial number of people. Right? I mean, I think Drama Alert may be able to go ahead and cite the views on the video, which, do we know? Does anybody know how many views? Maybe I can look this up. Let's see. Romeo Lacoste interview, 2.3 million views. Romeo Lacoste versus Keemstar, $3.5 million lawsuit response. Okay, that one's not going to count because that's an old one. Mr. G-Dubs, who is not Keemstar. So this is him talking about Keemstar's interview with Romeo. This is a year ago. 1.1 million views. Oh my God. Yeah. We've got I'm trying to find the other ones. It doesn't matter. My point is, these videos on Drama Alert have garnered millions of views. There's clearly a substantial amount of public interest, even if you want to consider Drama Alert the community. That's a substantial number of people. Thus, a matter of concern to the speaker and a relatively small, specific audience is not a matter of public interest. Try and convince a judge that the 8th largest city in the United States is not a significant number of people, right? 2 million views? That's a massive amount of people. David Smith, yes, probably. But at this point, that's not what they're arguing over. Okay. Third, there should be some degree of closeness between the challenge statements and the asserted public interest. I mean, the public interest is there a pedophile? Potentially working with kids, potentially on YouTube, doing videos for them, talking to minors and sending penis pictures to them. Is that happening? I don't care if it's one weirdo in a basement who no one's ever heard of sending pictures of his penis over Facebook to minors. That's public interest. That's public interest. Nobody wants that. Except for, you know, a few people who need to be probably quietly removed from society and put into padded rooms with no cell access or whatever. Nobody wants it. The public at large does not want it. We have laws against it for the reason that the public doesn't like it. You may like it. Go somewhere where that law doesn't exist. Hard to find a place where that law doesn't exist. Okay. Third, there should be some degree of closeness between the challenge statements and the asserted public interest. Fourth, the focus of the speaker's conduct should be public interest rather than a mere effort to gather ammunition for another round of private controversy. Now, here's a problem. Is there any evidence that Keemstar and Nico Lacoste have a private controversy happening? I haven't seen any. Finally, those charged with defamation, but they're not. You didn't charge him with defamation. Cannot, by their own conduct, create their own defense by making the claimant a public figure. I don't think... Let's take just a moment. I'm not going to do this often because we'll get drowned out in my sidetracking. Let's take just a moment and go to the... here we go. Here's the initial lawsuit. Statement of facts. Let's see. Oh, see, in their here's what they're trying to do here. They have him listed as he's just a guy in California and he's just got a business. Let's see, drama alert. Defendant. Plaintiff had no knowledge. Okay. It just says the plaintiff's business is a service-based industry and the damage caused to his business is from an aggregate loss of a mass of individual clients. So they don't really go into, in this document, in the complaint, how popular Romeo Lacoste is. Now, Keemstar does in his motion to strike. We're not going to go into that because I don't want to spend too much time. But the idea that Keemstar made Romeo a public figure, they did deal with this in the motion to strike, if I remember correctly, pointing out that he had 1 million YouTube followers and that he also, was talked about on his website for his public business, that he serviced a large amount of people, including very famous people. A person can, and was on a bunch of TV shows too. A person cannot turn otherwise private information to a matter of public interest simply by communicating it to a large number of people. Now, I don't think that anyone's arguing that happened here. How do I say this gently? How do I say this gently? You don't get to hide your pedophilia by merely claiming that you're only a pedo in private. I have to point that out. You don't get to hide being a pedo by saying you're not a pedo in public. It doesn't work that way. That's the whole nature of unlawful or illicit activity, is that it's in private. And when it comes to the public's attention, especially if that activity is unlawful, it's like, look, I only defraud people of banking information in private messages, so you can't point that out about me. Well, wait a minute. That runs contrary to public policy. We want people who are defrauding people in private messages to be caught. We want that to stop. Anyway, let's move on. Application of these factors show the defendant has done nothing more than attempt to convert private information. Plaintiff's sexual proclivities. No, Raul, don't do it. Don't suggest that your plaintiff's sexual proclivities involve minors. Please, why? No! Here's how you word that statement. Okay? Application of these factors show the defendant has done nothing more than to attempt to convert private information. Plaintiff's private conversations with other private individuals. That's it. Nothing else. Nothing. Nada. Just going ahead and running full bore with it. Look, it's not his fault he likes to send his penis to minors. What are we supposed to do? At least he's doing it in private. No. Why would you do this? Plaintiff's sex life is not of concern to a substantial number of people. Well, it actually probably is. Shockingly, the sex lives of famous people, even marginally famous people, have long been the concern of substantial numbers of people. That's why tabloids exist at all. That you go tell the National Enquirer that no one cares about Susan Sarandon's washed up sex life, and they will show you dozens of articles or all sorts of user, I don't know if Susan Sarandon actually is involved in that, but like you could just pick anybody, people you wouldn't expect. Of course they care about famous people's sexual proclivities. Famous people tend to be the weirdest people. So you really want to know how much cock and ball torture Mel Gibson's into. Like you've gotta find out. People buy it every day. As will be discussed in detail below, defendant's statements are not related to the public interest. Rather, defendant asserts that plaintiff's business should suffer and that plaintiff should be incarcerated for his alleged acts. Yeah, I'm with you, Keem. He should be incarcerated for his alleged acts, or at least evaluated. His case should be brought before a district attorney to determine if they have sufficient information to prosecute him for any specific crime. Other than that, homegirl need therapy. Get that man a Dr. Phil and put him on a couch. Perhaps most importantly, defendant's conduct is only an effort to gather ammunition for another round of private controversy. Defendant admittedly operates a YouTube news site. No. Don't call it a news site. If it's news, it's news. Defendant admittedly operates a YouTube rumor site. Say that. And boasts of his social media engagement. Yes. Just like the New York Times boasts of its circulation. The purpose of the statements at issue here are not to contribute in any meaningful way to a public debate. Rather, the comments seek to draw more interest in defendant's YouTube channel at the expense of plaintiff. Now, that is just true, but also defamatory. Damn you. I'm joking. Yeah, you cover stories people are interested in. That's how drama and news in tandem work. Ask everybody. Just go ask ABC or CNN or Steven Crowder or literally anyone. It's where the significant public interest meets the salacious bit of information you can give them. That's when you create views. Is that about increasing exposure to your channel? I mean, sure, it's a business, but the business is the salacious news that's being given to people who want it. By damaging plaintiff's economic prospects, defendant seeks to enhance his own by publishing lurid and unsubstantiated claims, in brackets, which we have admitted to. Defendant likens plaintiff's claim to Terry versus Davis Community Church to argue that defendant's statements involve the public interest. In that case, California Court of Appeals found that the issue as to whether or not an adult who interacts with minors in a church youth program has engaged in an inappropriate relationship with any of the minors is clearly a matter of public interest. Now, mind you, an adult at a church interacting with youth group minors is less public interest than a pseudo celebrity interacting with minors outside of youth groups, but abusing his social media contacts and prowess to prey on young girls. That is only in that community, in Terry versus Davis Community Church, only there is your child at risk. Only if you go to that church and put your child in the youth program are they at risk. Romeo Lacoste has a broad social media footprint and access to minor girls all over the earth. There is no 14 or 15-year-old girl who is safe from a gnarled picture of his penis or weird pictures of his neck tattoos. Nobody is safe. You can't hide your children. You can't hide your women. They cannot be kept from Romeo Lacoste. He has access to all of them. He will peer lustily into their DMs. He will slide lubricated into them. There's nothing you can do about it. It is way more a matter of a bigger public interest when someone is abusing social media to prey on young girls than in one church, which is also a matter of clear public interest. Plaintiff's case is distinguishable. Yes, plaintiff has never been to church. No, I'm just kidding. Plaintiff's job does not involve interaction with minors. No, but his texts do. Plaintiff runs a tattoo shop, which by its nature excludes minors. Every person who tattoos or offers a tattoo to a person under the age of 18 is guilty of a misdemeanor. Hey, pal, homie, Raul, when sculpting a narrative, this isn't legal advice, Raul, this is narrative advice. When sculpting a narrative, first of all, you don't need 2 periods making it look like a guy with an upside down nose or whatever. When sculpting your narrative, don't include a lawful restraint on the age of the other party when your client is accused of violating a lawful restraint based on the age of the other party, e.g., sending penis pictures to a minor. Your client is accused of violating a sacred age-based restriction that's enshrined in law. And you're saying, well, look, he would never tattoo a minor, but he'd send his cock? Like, what are you talking about? He'd ask them to have sexual activity with him prior to them turning 18 specifically? Like, but he wouldn't do a tattoo, though. He wouldn't. Whoa, that's a bit too far. I mean, tattooing them. It offers a stark contrast to the situation in Terry, where parents entrusted their children to a church camp counselor. Your homeboy preys on kids via text messages. Their parents aren't even a barrier there. Whether a tattoo artist has a sexual interest in underage persons is not a matter of public interest. No! Why didn't I just keep reading? Why would he do it? No! No, no, no! This episode is not brought to you by Grape Crush. Oh, no! Defendant also attempts to classify his statements as involving public interest by arguing that the statements are in the nature of consumer protection information. They are comparable to a warning to consumers not to do business with plaintiffs because of their alleged faulty business practices. Yeah, one faulty business practice, by the way, is not related to tattooing, but YouTubing, and that's called sending cock pics to minors. Oh. Defendant statements have nothing to do with plaintiff's ability to operate his business or his proficiency in his line of work. Wrong. You're skipping a line of work that they talked about. His YouTube channel, his public or his media appearances. It's his media and social influence. That's the scary thing here. That's where he's got access to these women. That's where he's not preying on them in the tattoo parlor. He wouldn't even tattoo an 18-year-old girl or a sub 18-year-old girl in the tattoo parlor. It's in the DMs. It's in the DMs. That's part of his other business activity. Therefore, the statements cannot properly be classified as consumer protections or warnings. Now, if I'm not mistaken, Keemstar will get a response to this as well, which I'm sure they will reiterate because they don't even need to clarify. They just need to remind the judge that this guy admits to being attracted to minors and runs a public business and a giant YouTube channel with access to minors, as shown by the interviews with all of the minors. That's all they need to do. Judge, dude's a creep. Dude's a pedophile. And he's preying on underage girls. And he's just saying, look, Yeah, I do that, but I do it in private, though. That's the argument so far. Even if plaintiff's conversations were in the public interest. Defendant's tortious acts in no way contribute to the public debate and bear no functional relationship to it. Defendant stated that plaintiff is finished. Plaintiff's career is finished, and plaintiff belongs in a cage. Opinion, opinion, opinion. Like, all of those are clearly protected opinions. You can say all of those things. By the way, Romeo Lacoste belongs in a cage. Romeo Lacoste belongs in a cage. Romeo Lacoste deserves Mike Pence electroshock therapy, personally administered by Mike Pence, with General Mattis weeping in a corner, crying over the loss of electrical outlets that he could use to interrogate the Taliban. He deserves all of that. That's an opinion. That's an opinion. And if it doesn't fix him to get the electroshock, he doesn't deserve to be let out of the cage. He's abused it. Put him in. These statements propose punishments, both pecuniary and legal. No, they don't. That's not a proposed punishment. That's an observation and opinion. Look, he's not going to recover from this. It doesn't say plaintiff should be finished or I will finish plaintiff off. Don't say that to Romeo. He'd get excited and text you. Only if you're under 18. For actions defendant believe occurred. You admitted to them. He interviewed the person who they occurred to. And then he interviewed your client, who also admitted to them. They did not discuss the allegations or their effect on the alleged victims. They what? I'm sorry. I'm sorry. Hold on. Okay. Here's a big issue that we've got right here. This is a big issue. All right. Defendant used this video, you know, whatever, the video of him sending his penis to a minor, in his efforts to destroy defendant's business and reputation. Defendant has stated multiple times that plaintiff is finished, plaintiff's career is finished, and plaintiff belongs in a cage. I think I didn't understand this the first time I read this because, pardon me to all retarded people, I apologize for lumping Raul Severo in there with you. It was too retarded for me to understand what his argument was. It doesn't make any sense. He's actually suing Keemstar over this line right here. I didn't catch this before because it is so unreasonably stupid that I couldn't get this. I couldn't pick this up. He is suing over the three specific statements. Plaintiff is finished, plaintiff's career is finished, and plaintiff belongs in a cage. That's it. That's the crux of his lawsuit. I mean, I thought naively, as a dummy, that he was arguing that the totality of the videos that Keemstar made about Romeo, like the whole message, the whole thing, was a ruse to destroy Romeo's business. But now that I look at it, plaintiff believes and alleges that defendant's conduct as alleged above, it's literally, this is the only conduct they actually allege. Using the video and then making these 3 statements. This conduct is about other people. Demonstrable history for making accusations, notably for accusations of pedophilia, which is unable to substantiate, yet recklessly and maliciously continues to make accusations. So even if I read that as written, that's about other people. He's talking about other accusations. The accusations made against plaintiff, see, these are other accusations, then the plaintiff have caused substantial damage, and then here's the accusation. This is it. And look at this. Defendant stated that these 3 things, these statements, proposed punishments, both pecuniary and legal for actions defendant believe occurred, they did not discuss the allegations or the effect on the alleged victims. I mean, Keemstar has definitely discussed the allegations. He definitely did. He talked with the alleged victim. He showed her video. He did an interview. He discussed it with Romeo Lacoste. He absolutely discussed the allegations and their effects on the alleged victims, not only with the victims and with the public, but with Romeo himself. Like, he did that. But they're not suing over that. They're suing over these 3 lines. I'm dumbstruck right now. I legitimately, I'm flabbergasted. Keem, if you're out there, to your lawyers, I hope they saw that before I did. I'm guessing they did because it's their job. That is the stupidest thing I've ever said. Yes, ever seen. Like, that's mind-blowing. These statements were simply aimed at damaging plaintiff's reputation and business interests. Imagine, if you will, you see someone, you're at a restaurant, right? You're at a restaurant, you're having your dinner, and you see half of the restaurant get up, throw their table over, and leave as they parade a 14-year-old Ukrainian prostitute through the restaurant and say, she's also on the menu, boys. And everybody flips their table. Well, most everybody flips their tables, gets up and leaves. And you go, well, this place is finished. And then they sue you for tortious interference for saying this place is finished. Think about that. They're not suing Keemstar. According to this, they're not suing Keemstar because he said Romeo Lacoste had sexually explicit conversations with a minor. That's not listed. They're not suing Keemstar for saying Romeo Lacoste texted a picture of his penis or a video of his penis to a minor. They're saying that they're suing Keemstar for saying plaintiff is finished. Like, think of that. Whew. Okay. Romeo, you're finished, homie. You are done. Oh my God. And increasing defendant's business interest by drawing more viewers to his YouTube channel. By the way, there's nothing wrong with doing that. That is not only a protected activity, but an encouraged one. The public has no interest in plaintiff's sustained business interests or whether plaintiff should be incarcerated. Look at this. These three statements they're focusing on. This is their theory for a matter of public concern because they're tacitly admitting that he's sexually attracted to minors. Like they're going with that one. Like we're going to run with this. We're going to run with this project right here. See how that one works out for a little while. That's what they're admitting already. But they're saying that his sustained business interest, you're finished and your career is finished, and whether should be incarcerated, belongs in a cage. Maybe it's not a prison, by the way. That's an idiom. Belonging in a cage. He could be into cuckoldry. He could be into cage fetish. We don't know. We don't know. He could love the Ram Ranch. Have no idea. Maybe he's getting sued along with the rest of the gays. That's mind-blowing. No one saw this coming. I can't. My brain broke. Did you guys ever see that episode of South Park where Cartman got Kenny for school pictures to get into his parka upside down and backwards, so his anus and butt crack were in the parka's face thing, and they took the school pictures, and then he submitted him as a lost child with a brown eye, right? And Cartman pulled his funny muscle. I can't laugh. I pulled my funny muscle. He couldn't do it. That's how I feel right now. Or was it Funny Bone? Whatever it was, Funny Fuse. I don't know what to do with this. This is so stupid. I'm broken. I'm stuck in a loop. One of those infinity loops. Therefore, assuming an individual's sexual proclivities are a matter of public interest, the complained of statements had nothing to contribute to the debate. Oh my God! Here we are, us rubes of the internet, not knowing the brilliant Raul Saavedra's plan. His legal strategy was so much lower brow than any of us could imagine. Keem, actually, you gotta run to your lawyers immediately and tell them he's not even talking about the sex stuff. He's literally suing on 3 statements. Romeo Lacoste is finished, Romeo's career is finished, and Romeo belongs in a cage. That's it. That's it. That's the entire foundation for his lawsuit, according to this document. It is mind-blowingly stupid. Raul he's a better lawyer than anyone I've ever met. Because no one would see this coming. God, I wish... Oh my God, I wish Mr. Peacock was here for this. I really do. I need someone to help me. I need help. I need a friend. I need a grown-up. Help. I need a buddy who can... Please. Please. I don't know. I'll text him. Hold on. I just texted him. If he texts me back, I will bring him on. I'm just going to go ahead and set up the Google Meet right now. And if he jumps on, we'll be in. Just give me one moment. I need help from my bro, right? Like, I need it. Okay. Okay, if he comes on, I will let you know. Oh, wait. Oh, he's coming. He's coming. Oh, baby. Okay, just a second. We got it. We need this. Freighter J says, almost like the kind of filing that an imbecile who's been disbarred multiple times would make, isn't it? I mean, maybe. I can't. Let me make sure we're on the right. Okay. I'll unmute him. The second he's on, I'll bring him on. Here we go. Oh, hey, look, that's me. That's weird. Get that out of there. It's uncomfortable seeing yourself. Twice. Seeing myself twice is weird. Which one is the real Nick? One of us is backwards. One of us is... Hey! You suck! I hate you. All right. Oh my gosh. I hate my other camera. I need to white balance that thing. I'm just gonna wait. I don't want to get past this. I'm sorry for all of you beautiful people out there. I think this will be worthy. Shill your second channel while waiting on Mr. Peacock. Okay, my second channel is Rekieta Media. It's where we discuss things that are not related to law in any way. So, you know, if you want to talk about video games, if you want to talk about books, sci-fi, nerd crap, D&D, all of that stuff is that's for Rekieta Media. You can check me out there. And when I don't do live streams on this show, on this channel on weekdays, and sometimes on weekends, they will be over there, more chilled out, non-legally related content. All right, I need him. I need him to show up. Please, Mr. Peacock. You're our only hope. Okay, the Red Pill Journey says, Romeo and his lawyer sound like the kind of guys who weren't loved enough by their parents. Here's 20 to get you through the suck. It's bad, man. All right. I'll go on waiting for Mr. Peacock. I assume he's just getting his computer booted up. We'll go on just a little bit. Neither the plaintiff nor defendants qualifies as a public figure. Okay. Defendant also argues that plaintiff's claim arises from the defendant's exercise of his right to free speech because Romeo is in the public eye, and therefore this is a matter of public interest. But Section 425.16 does not protect any speech simply because it involves a person in the public eye. C. Wilson, holding that a statement is about a person or entity in the public eye may be sufficient, but is not necessary to establish the statement is free speech in connection with a public issue. That's not a good citation. Look at this. Look at this. A statement is about a person or entity in the public eye may be sufficient. That alone may be sufficient, but it's not even necessary to establish the statement as free speech and connected with a public issue. You don't... What they're saying in Wilson is not that a statement about a public figure is not of public interest. It's saying that you don't need a public figure to have a statement in the public interest. That is absolutely... That is a terrible citation. Defendant's argument is essentially that any statement involving a public figure is one of public interest. I mean, it kind of is, actually. That's what it is. Oh my God, I can't wait. Oh, Mr. Peacock. Can you hear me? No! Oh, there you are. Hey.
All right, great, perfect.
Hold on, let me get you on the screen here.
Thank you. Get me in the chat too. What is going on? What is so exciting?
Do you need a chat link?
I would like to look at it just for while I'm here for these 10 minutes or however long.
Yeah. Well, you can stay as long as you like. Let me get you.
God bless you.
My dude, I'm covering that Romeo Lacoste versus Keemstar lawsuit that you and I have been covering, right?
Right.
Okay.
More you, and I'm just laughing along as
you've been here
does.
for every show about it, every live stream about it, just about. So
That's a good point.
So look, I thank you. I know you were engaged in wonderful like sleep or whatever. But I need... You're
worth it, buddy.
I need
And your fans are worth it, too. Everyone go subscribe to my channel and listen to the recent videos. I really should delete the old ones with shitty... What's the word? Audio. Because the new ones have good audio, and no one seems to understand that. God damn it.
No,
I'm going to delete them right now. Fuck it. What's going on?
Don't delete it. Trust me. Don't delete it.
Oh, just the bad ones. Just the bad ones.
I'm giving you YouTube advice. Don't delete them yet.
Sure.
Talk to me about it first. Okay.
Right.
Oh, this one's for you. Iron Mater says, "Give us the Dune stream, or I jerk it to your feet pics."
You want to see my? Hold on, wait. There we go. Show them feet.
No! Oh, no! Rookie mistake. I didn't prepare you. Oh God.
No, that's if they really want to do it, that's fine. That's
Okay,
good for you. We're here to spread joy in the world. If you really want to rub one out to these peacock feet, you go ahead.
And everybody does. Everybody wants
Well, can you blame them?
Okay. So I am, I've got the documents up. Now, we were under the assumption, and this is, I believe, I've just found out that this is an erroneous assumption, that this guy was suing Keemstar for outing that he was sexually attracted to minors, right? Like, that was your understanding?
Right. I mean, that's what one gains from reading the complaint at all.
I challenge that assertion. I think we did not read carefully enough. So,
in our defense, it is so poorly written and so filled with ridiculous assertions that one cannot read it carefully enough.
It's expertly crafted, but the expertise is in lunacy. I've learned this.
Superb.
Okay, so I'm going to, how do I, if you, I don't know how to get this here. I'm going to send you the stream link. God damn it. I don't know if you have enough screen real estate for it, but I've got the,
I'll figure it out.
I've got the document pulled up. So here's the link to the stream, just so you can see the actual document itself. I'm sending it on Twitter right now.
Okay.
Okay. So, and I will preface this while you get it pulled up.
Sure.
So Keemstar filed his motion to strike the entire complaint, right? We covered that for the anti-SLAPP.
I recall that, yeah.
And now Nico has submitted his opposition. Now, first thing he did was he failed to title it opposition, and he failed to properly double space a block quote. So it was rejected by the court. And,
of course.
And he was given until noon on the next day. And he missed that by an entire day.
I vaguely recall laughing about this. For everyone, I apologize. After that first bottle of wine, I don't remember anything. Evidently, you were licking a cutout of Ron Toye's face, which I don't...
Never happened.
Yeah, that sounds ridiculous. Someone said that. I don't believe it.
That never happened.
No, it would not.
Yeah, this is a couth stream, and that was uncouth.
Right.
Okay,
all right, so I am looking at a very fuzzy version of this video because I guess I don't have enough bandwidth to upload and watch at the same time.
Well,
Goddamn Spectrum.
I'm going to read it to you.
Alrighty.
Oh, you know what I can do? I can do this. I can share the screen with you and not with the audience.
Great.
Here we go. Let me share, present a window. This one, share. Okay. Well, maybe it will share with the audience. But...
All right. Well, audience, if you see that, let us know so that we can unshare it. But I can see it now perfectly. Okay.
It's weird. Okay. Anyway, well, it's going to be up there. All right. So this is his opposition. Now, he did submit an opposition on the 14th, which is, 24 hours after he was supposed to submit it. And the judge also struck that one. And now he has objected to it, saying, but my internet didn't work, so I didn't get the email. So that's, I just want, there. That's what I wanted. Okay, now everybody can see you, but you can see the thing. Okay, so he said my internet didn't work, so it didn't send me the email. So they're objecting to it and asking the judge to consider the pleading or the motion opposition. So that's what we're going through. But read this starting here, if we can.
Okay.
Are you ready for this?
Out loud or to myself?
You can read it out loud or I can read it to you. Which one would you prefer?
Please read it to me. It's your show, and everyone loves your voice.
Even if plaintiff's conversations were in the public interest, his sexual conversations.
I just got to say that is a really bad start when there's an anti-SLAPP motion.
I've got to go back. Like, I won't do it now, but he says basically that, look, the fact that my client is sexually attracted to minors is not in the public interest. He actually says that. I'm not even paraphrasing.
I mean, I am confident that there is case law on point saying he's wrong. I have not even researched this because it's so obviously wrong.
But it doesn't even matter, because I'm telling you, that's not even their argument. So here we go.
All right, I'm excited.
Even if plaintiff's conversations were in the public interest, defendants' tortious acts in no way contribute to the public debate and bear no functional relationship to it.
Well, that is false.
Hold on.
Off the bat.
No, it's not, and I'm going to show you why. You're at D level lawyer. You got to get up to S tier, my friend. Defendant stated that plaintiff is finished, plaintiff's career is finished, and plaintiff belongs in a cage. Those are 3 different quotes.
Mm-hmm. They're all opinions, too.
These statements propose punishments, both pecuniary and legal, for actions defendant believe occurred. Now, I know this is slowly drilling into your brain because it's not your fault. It took me a minute. Those 3 statements are the entire foundation for the lawsuit.
No, I don't believe that. If that was the case, then he would have left out the whole part in his complaint about, so, I mean, yeah, I did bang a 16-year-old, but then he went and said that I did. Like that, he would have left that part out. He just would have said, you know what, this guy's over here. He's saying that my career is over, that I'm finished. And the fact that he has 100,000 YouTube followers, he is a man of influence and power.
A million YouTube followers.
A million. He is a man of influence and power. He controls the opinion of 1/3 of 1% of this entire nation. He can influence them. And of course, that just compounds. And so he's saying that I don't have a career anymore, ostensibly because he thinks I'm a bad artist. I don't know. That would be something to base a claim on, I suppose, but not that. If that's it, you don't need to admit that you're a pedophile, moron. Oh my God.
And I support this with the follow-up. They did not discuss the allegations. They, being those statements, did not discuss the allegations or their effect on the alleged victims. These statements were simply aimed at damaging plaintiff's reputation and business interests and increasing defendant's business interests by drawing more viewers to his YouTube channel. And Mr. Peacock, look, I've now pulled up the original complaint. Look at what this is the only alleged statement in the entire complaint. Defendant has stated multiple times that plaintiff is finished, plaintiff's career is finished, and plaintiff belongs in a cage.
You know, you're right. That actually, now that I'm sober, that stands to reason. It's retarded. It's stupid. It is.
It's unbelievable.
No, guys, you don't understand. I think Rackets and I are the only people right now who understand just how bad this is. This is such a poorly thought out complaint. He might get sanctions just for filing it. Like,
he should. He absolutely should. I was convinced, 100% convinced, that the allegations were that he mischaracterized him as someone who is sexually attracted to minors, that he misconstrued the statements, that he was a danger to other people. No, it's literally these 3 sentences.
So here's the biggest part. All of those are statements of opinion, right? Every single one. They are statements of opinion relating to a self-proclaimed public figure. And they might be defensible in the most ridiculous, most punitive jurisdiction on the planet, but for the fact that in this guy's own complaint, he laid out the basis for those opinions, right? So, guys, those of you who may not understand, if you say a defamatory opinion of a person, but you imply that that opinion is based on facts that you're withholding, then that opinion can, in some instances, be actionable, right? Because you're implying the existence of facts that a reasonable person would take to be destructive. I forget the precise words. I'm just waking up, guys.
Basically, you say, look.
Hey, don't ask me why, but I'm telling you that this guy over here, that he should be in jail for beating his wife. Don't ask me why, but I'm telling you, I just think that's what he should do.
Yeah, I just have a strong hunch based on things I know that this guy should be in jail for beating his wife, right?
Right.
And that,
on the other hand,
just my opinion, though.
Right. And that could be actionable in some instances. On the other hand, if I say, yeah, you know what? Watching that guy drink a Coca-Cola, you can tell that he probably beats his wife. I mean, I think just looking at him, the way he drinks a Coke, he beats his wife. That's not defamatory because you're explaining all of the bases for your opinion, and a reasonable person can listen to you and say, oh, you're just stupid. That doesn't make any sense. And they can decide for themselves. But in this case, he's saying my career is finished just because I banged a 16-year-old, right? He's shooting himself in the foot before he even puts on his shoes.
But he's not
is what we're saying.
He's not even going that far. The entirety of the statement is plaintiff's career is finished. Like, I can't get into that statement. I don't see how in any way, under any even strained facts, and him being O.J. Simpson and the judge literally being the reincarnation of Nicole Brown, I cannot see how Romeo Lacoste is finished is defamatory ever. Like, it's not even,
no,
it's not, because if they would have said Romeo Lacoste is finished because he fingers underage girls, yeah, okay, well, like, or because Romeo Lacoste is finished because I have information about his pedophilia, or because something like that. But this is literally just, he's finished, his career is finished, and he belongs in a cage. Those 3 statements are purest of opinion.
It's everything about these complaints make me wonder whether the attorney knew what he was doing, or looked at the law at all, or had some huge brain strategy where he was like, oh, this guy has 1 million YouTube followers. He's going to want to nip this in the bud. As soon as we file, we're going to get a settlement like that. Yeah, you know what? Maybe that worked in the 1940s with you sue a movie star and the studio doesn't want any big hubbub over them because of how the politics of the entertainment industry worked back then. I think this guy's just out of touch. I refuse to believe that this lawyer is so incompetent that he did that, or that he doesn't understand what the law is. I think this had to have been some strategy where he big-brained himself by thinking he was 70 years ago. Also, I want to take this opportunity to remind all of you, this is a comedy podcast for informative shows, or informative reasons. Do not take anything we say as legal advice. We're just discussing, you're just listening. We are not advising you. This has nothing to do with your case. Consult with local counsel. That applies for any time you hear either of us talk if you're not paying us, including the times when I am too drunk to remember to say that.
Yes. If you're getting your actual legal advice from a lawyer on the internet who's talking generally about something, get legal and psychiatric advice from someone else. But here we go. The public has no interest in plaintiff's sustained business interests, or whether plaintiff should be incarcerated. I mean, every sentence reinforces the fact that it's just these 3 statements that they're suing over.
I mean,
which is not only, I mean, that's improper, because even if you say, like, Keem would have a defense, because he'd say, look, you've taken 3 statements out of 45 minutes of video. You have to take the entire publication. You can't take just 3 statements. You have to take the gist of the entire, at least I think so. I assume it's the same in California. You have to take
in California, we have what's called the completeness doctrine.
Yeah. So it's wild. Therefore, assuming an individual's sexual proclivities are a matter of public interest, the complaint of statements had nothing to contribute to the debate. It's literally...
Well, but here's the thing. He's bringing... Even right now, when he's saying, look, all we're mad about is that he said that our career is finished and that we belong in a cage and that we're done. That's what we're mad about, because what I do in my bedroom has it's totally irrelevant to all of this. So he's bringing the pedophilia back in the alleged pedophilia, admitted pedophilia, whatever the fuck he did, the weird shit that he did with a minor. He's bringing that right back into play. So his entire argument that, whoa, all that stuff doesn't matter. What's important is what he said it will do to our career. There's not an argument here, guys. Ambush
question. How do you rate this sentence on a scale of 1 to 10? Application of these factors show that defendant has done nothing more than to attempt to convert private information, plaintiff's sexual proclivities, into a public interest by discussing it on his new YouTube news channels.
Oh boy. Guys, this guy has done nothing more. He's a news anchor, by the way, has done nothing more than talk about what my client, who is a celebrity, an admitted celebrity, by the way, it says that in our pleadings, has done nothing more than talk about what my client does in the bedroom. In other words, this guy is running a tabloid site, and we're trying to get him for that. No, you can't do that. Tabloids are constitutionally protected. I'm sorry. If you start a complaint for defamation with the words, plaintiff is a public figure, you better be ready to fucking go to war, because there's a very good chance you're going to lose, and you just lost.
Now, minor counterpoint, because I did the same thing. They actually, I will give him credit on the complaint. They don't mention anywhere that this guy has any people who know who he is at all. That was all brought up. That was all brought up in the motion to strike, where they point, point out his YouTube videos, where they point out him claiming to be a celebrity tattoo artist. They point out the fact that he's on like TV shows on Lifetime or whatever. I can't remember what stupid channel he was on, but when because I thought the exact same thing. I was like, oh, he admitted to being a public figure, but no, he does not. In the actual complaint, he's just a humble tattoo artist, and that's all you. The closest thing you get is that he lost a mass of individual clients. That's it.
He didn't name any of the clients?
Didn't name a single one.
Got it.
But that's it. Now, in Keemstar's motion to strike, of course, he lays out very clearly who he is. But still, like, you have to know, if you've got a 1 million subscriber YouTube channel and you've got a business where you claim to be the tattoo artist for celebrities, you're going to be called a public figure. And you're certainly... Yeah. And just to be clear, guys, when you go and do an interview to try and mitigate the damage, you're a limited purpose public figure already. Like, that interview itself, I mean, other than, like, you can maybe get away with a general denial. Look, I've heard some stuff. I deny everything. That's about it. If you start trying to influence public opinion on interviews, you're gonna be in trouble. But yeah, man, I don't want to keep you forever. You can, of course, stay if you want, but I know you have like
7 more minutes, just because I love you and I love all of your listeners.
Okay. So let's see. So they have a really bad citation here that I just went through right before you got on, and I want to go with it.
That's a good start.
So defendant also argues that plaintiff's claim arises from defendant's exercise of his right to free speech because Romeo was in the public eye, and therefore this is a matter of public interest. Well, yes. But Section 425.16 does not protect any speech simply because it involves a person in the public eye. And then they cite Wilson, and they holding that, quote, a statement is about a person or entity in the public eye may be sufficient, but is not necessary to establish the statement is free speech in connection with a public issue or an issue of public interest.
That citation says the exact opposite of what you're citing it for.
Yes, thank you. It says basically that it's a public figure might in fact be enough, but you don't even need to have a public figure to have a public issue, right? Like, I'm not reading that wrong. I don't think.
Oh, no, that. So I don't have Wilson committed to memory, but that looks to me like that's exactly what it's saying.
Even their quote, like, even the quote says that, the one that they chose.
Right. I mean, they could have chosen a million other quotes, and well, yeah, in California, you're allowed to cite dicta and as a mistake, right? Like, that's, you can a bad lawyer doesn't get penalized other than losing if he cites the wrong part of the case and claim it's a holding.
Yeah.
Unless he's obviously trying to mislead the court. But I mean, there had to have been some wiggle room here that he could have picked something. Maybe at least put the burden on Keem's lawyers to actually do the work.
Defendant's argument
doing it for them.
Defendant's argument is essentially that any statement involving a public figure is one of public interest. Yet defendant presents no authority for that proposition. That is because there is none. Again, quote, a person cannot turn otherwise private information into a matter of public interest simply by communicating it to a large number of people. That is exactly what defendant seeks to do here. Defendant's interpretation of the anti-SLAPP statute would improperly expand the scope of protected speech beyond what the law allows. Moreover, there is a real question of fact as to whether either plaintiff or defendant is in fact a public figure. Now,
no, there isn't.
Now, Romeo has 1 million YouTube followers, and Keemstar has like 4 million or something, maybe more. I don't know. It's a lot.
I mean, that is, guys, when you consider 1 million, that's more than.
I categorize it this way. That's 1 million is like the 9th largest city in the United States.
Right, exactly. Exactly.
And every single person in that city knows you. And not only knows you, but follows you.
Right. If you pick a like primetime TV show, I'm pretty sure your like shitty primetime TV show that you don't remember because they get canceled after the first season. They have less than 1 million viewers, which is why they get canceled, but they're still on TV and everyone knows what they are. Like if I don't want to. Like King, well, no, King. Anyway, I'm not thinking good. I see someone wants to touch my mustache. Are you pretty lady? Yes, you're free to touch my mustache. Kiwi Havoc.
That was actually me on one of my alt accounts.
That's why you can touch it. That's fine.
Okay,
we've known each other that long.
Okay, there are two categories in which a person can be a public figure. One, where a person achieves such pervasive fame or notoriety, it becomes a public figure for all purposes and in all contexts. And two, more commonly, where an individual voluntarily injects himself or is drawn into a particular public controversy and thereby becomes a public figure for a limited range of issues. Gertz versus Welch. Defendant claims that plaintiff is a public figure because he has hundreds of thousands of followers on social media and has appeared on a reality television show. However, having followers...
Whoa, guys, he's not a public figure. He was just on TV.
However, having followers on his social media accounts fails to establish pervasive fame or notoriety. In today's society, it is not uncommon for users of social media to have numerous followers. Having social media followers in and of itself does not establish fame or notoriety. Oh, there's a footnote. Footnotes are great. This court should not credit the statement made in the cease and desist letter. Oh, that's where we got it. It was the cease and desist letter regarding plaintiff's public figure status as relevant to the question at this stage in the proceedings. Let me remind you what that statement was, because I forgot about it until literally just now. Here we go. I'm pulling it up. Here's the cease and desist letter. Where is it? Mr. Lacoste is a public figure.
Yeah. Wait, was that attached as an exhibit to the complaint?
I think it was attached in the motion to strike.
I mean, either way, guys, when
you can't make a statement and say, "Look, I'm a public figure," and then be like, "Well, you shouldn't listen to me when I said I was a public figure in a legal threat."
I was using that for leverage here. I didn't think it was actually going to get in front of the court.
Your Honor, you can't hold me to my own standards.
I'm not sure that Federal Rule of Evidence, what is it, 803, that prohibits settlement compromises or evidence of offers to settle. I'm not sure that includes all statements made in any communication, especially when a cease and desist letter isn't actually a settlement offer. It's not saying, "Hey, stop and we'll give you this." It's just saying, "Hey, don't do that."
Yeah, it's not a protected settlement negotiation, and it's a statement against party interest. So it's gonna be, it's gonna get around pretty much any objection, because like, look, you can't listen to what I said about me that's negative. Of course you can. Like that's the whole purpose.
Guys, I just want you all to know, before I go very shortly, this is the kind of thing that if I read from the other side, me and the entire firm, even the secretaries, would be laughing at looking at this just because of how bad. Well, there's one guy in my firm who doesn't laugh, but everyone else would be cracking up at how poorly written this is.
Is it your tax guy or bankruptcy guy?
No, he laughs all the time.
Oh, okay. Okay.
Yeah. Maybe I'll tell you off stream, but yeah, oh man, you know what? I really want to give the lawyer the benefit of the doubt. I think what happened was he didn't realize, like his client came in, said, "Hey, this guy's saying this stuff about me," and the lawyer just didn't realize how bad the case was, and now he's just trying to pull a rabbit out of his hat. That has to be that. I don't want to say this lawyer is incompetent or bad or an idiot. I'm trying. We've all had a client who comes into our office and promises us the moon in facts, and then you look at the actual evidence and you say, "Oh, no, dude, you're going to jail," or "No, this is a loser. We need to get out of it." Yeah. We've all had that. I'm hoping that's what it is for this guy, but the money is too good, so he just keeps billing and trying to get there. I don't know.
Okay. I'm going to let you go right after this, because this is just finishing out that cease and desist footnote and letter. So a cease and desist letter can be interpreted as a compromise offer negotiation and is not admissible to prove a disputed claim under the Federal Rules of Evidence 408, see US v. King. Now, I don't know, not being fully versed in Rule 408 and how it plays out, but it says can be offered, can be considered as an offer. Now I want to get to this letter real quick. We respectfully demand that your network remove the videos and posts, and that no similar postings of this misleading content be allowed on your network. Video's claims are slanderous, being skewed in a light designed to damage Mr. Lacoste's career, have already had a monetary impact upon his business. Mr. Lacoste is a public figure, and continued publication of these videos and posts will be considered malicious in nature, for which we will seek both compensatory and punitive damages. I don't know.
Yes, I don't see any facts contained in that excerpt that would tend to support a finding that it's a settlement demand, right?
Me
because
either.
It's not, there's no, so guys, for those of you who don't know, when you're interpreting case law, you always have to look at the facts of that specific case and the basis for the court's reasoning. Not having read that case that this guy just cited as to why this should not be allowed in, I know for a fact that case has to have had facts distinct from it. Like a cease and desist letter must have said something like, hey, you're doing this shit, cut it out. And you know what, just to sweeten the pot, if you agree to cut it out, we will go ahead and do X, or we will agree to stop saying your name too, or something like that. But this is just straight up saying, hey, do this or else. And that or else cannot, under any reasonable analysis, make it a
settlement offer. Yeah.
Yeah.
And there's no indication that they interpreted it as a settlement offer. We don't have any information. Like, they could have included an exhibit where they responded and tried to negotiate and started settlement from it. But no, of course we don't have that. But anyway, man, I don't want to keep you all night. I know it's late, and I saw this and I was like, my man Peacock has to see this.
I'm glad you brought me on, man. This was much funner than sitting in bed.
Because we were too stupid to see the master play.
Yeah, that's right. We were too dumb. We were caught up in all the little salacious facts and not the hardcore details. And I guess that's why we're not millionaire lawyers yet.
Yeah.
Anyway, are there any super chats or anything before I go?
There's one specifically for you from Gelth Walker that says, Mr. Peacock, did your lady friend come over? That's from Mama Bear. We all want to know. Nick, just to brag, I'm going for a haircut tomorrow. Shaggy, I hate you, Gelth. Sorry.
Very quickly, I'm speaking of haircuts. I'm actually very excited that the LA lockdown is going to continue for 3 months. Those of you who may not know, I had hair down to here. I looked like fucking Fabio. Then I got a haircut because I decided I need to look professional. After 5 months, it might be pretty close to that again. I am pumped.
Get it back.
Did she come over? No, she did not come over, unfortunately. She went to bed. I haven't heard. Well, no, I heard from her the next day. Although just now, while I was on here, there was a 23-year-old girl who I met on Hinge or Bumble or one of them, and we were going to get ice cream the weekend before last. And then she just kind of dropped off the face of the earth. And she dropped off the face of the earth after I told her that I got a panicked phone call from a friend of mine growing up. Now, this friend of mine, you need to understand, went to prison for a crime of moral turpitude. Well, he robbed a place. He robbed a 7-Eleven, and I won't go into any more details than that.
Yeah.
But growing up, I always thought he had a speech impediment, right? But after this phone call, I thought, oh, no, maybe he's just retarded, because he got
come on.
He got catfished on Tinder by some chick who was using Taylor Swift's photograph, convinced him that it was actually Taylor Swift, and she wanted to send him a bunch of money. But first, he needed to transfer some of his money to an account in Canada for her.
I mean, it's reasonable.
Because here's why.
Yeah.
Because she got her identity stolen, and someone was using her picture and bank account information, so that was all frozen. So this person told him what he was doing. So my idiot friend said, oh, okay, that makes sense. And he sent the money. And then he realized what had happened.
Listen.
And then he called me panicking.
Maybe if I help Taylor Swift, she'll marry me.
Rackets, you're not going to believe this. I looked at the text messages that this dude, this like Pakistani or Bangladeshi or Nigerian or whoever dude was texting my friend. And he said something, he actually used those words like, oh, well, how are we going to get married if you can't even trust me to do this? And so now here's where it gets even better. It gets even better because my poor friend.
Is your friend named Russell Greer?
He is not named Russell Greer. No.
Damn it.
my buddy. Oh, we talked about him on that one time too, huh?
Yeah.
Anyway, so my buddy called panicking because he was saying, shit, like, am I going to get in trouble for this? Is this a violation of my parole? And I had to explain to him, no, man, you didn't do a crime. You're the victim of a crime. That you didn't scam anybody. You were just dumb enough to get scammed.
I was a willing participant. I was an accessory to my own defrauding.
Right, exactly. Like that's this isn't going to get you in trouble, you moron. Just don't do it again. But so anyway, after that, I sent this girl a text and I told her pretty much that whole story.
Yeah.
But I didn't hear from her. Right. And then I texted her a few days later after our date was supposed to be. Didn't hear from her.
Well, look, if you've got contacts to Taylor Swift, she was just intimidated. It's like, oh
right,
my
no,
God.
Exactly.
He could marry Taylor Swift at any moment. He's way out of my league.
Yeah, I go, I'd be hanging around a bunch of millionaire actress chicks. But so I get a text from her this morning just saying, just so you know, what was her exact words? I don't approve of, no, I don't take kindly to making fun of people because they're slow. And so all I can say, but like that is retarded. Like that's not your average level of stupid.
Diagnoses.
Right. But the really dumb part is the fact that he was concerned that it was going to be a violation of his parole, not that, hey, how do I get my money back, right? Like this guy is a bagger at the grocery store. The money, he transferred $2,500. That's like 3 months post-tax income for my guy.
Yeah.
Right?
Yeah, that's infinity money for a felon.
Yeah, his concern should have been, how do I get the money back? Not, am I going to go back to prison for getting robbed? But anyway, she just texted me while we're doing this saying, just out of curiosity, what did he go to prison for the first time? So
you got an in. Listen,
yeah, I think she wants to get back together.
Listen, girl, I can tell you how all kinds of guys went to prison.
Right? Sometimes I represented him. Not this one though. He went to prison a long time ago. Also, yeah, Freezy's Yaz, Keon. I mean, whoever Mr. Peacock stuck by that guy because we've known each other since we were like 6 years old. Yeah,
respect.
LA was weird growing up. Anyway, going to bed now. Everyone subscribe to my channel. Listen to the recent videos. If you click on a video and it has shitty audio, just ignore it. Just go to, I think episode 7 and episode 8 are both two-parters. They have good audio. Tune in this Sunday. I'll be reading excerpts from the Silmarillion, which is the, if you're a Tolkien nerd, it is the, yeah, it's like the encyclopedia that Tolkien wrote for himself so that he could keep everything straight while he was writing The Lord of the Rings. Good night, all of you. Thanks for having me, bud.
Hey, thanks, buddy. I appreciate it.
Sleep well and enjoy the, what's it called?
I don't know what it's called.
Dude, words are hard, man, right now. Enjoy the rest of your night. How about that?
You too, man. See ya. Oh, my goodness. Oh my goodness, that was Mr. Peacock. I'm sorry for the delay and the excursion. But I felt it necessary to bring on someone else to share in my misery. It had to happen. It had to happen at some point. The Stealth Hispanic says an update on the thought market. OnlyFans has been booting some content creators. The people involved claim OnlyFans is removing the more hardcore creators. They either have a standard or their payment processor is scared. Yeah, payment processors don't... Like porn sites have problems with payment processors as well. So yeah, it could be. Excuse me. Oh my goodness. Felipe Move says, hey Nick, now that the lawyer thing didn't work, are you going into the Elvis impersonator business? I see the Highland Park is done. Verdict. Oh. Highland Park 18 is fantastic. I really appreciate that it was sent to me. Let's get this. Let's get through this document. We're actually pretty close. We're pretty close to done. Okay, back to it. Having many social media followers shows only that a person is known to that immediate subset of the social media platform's users. Yeah. And that could be enough to be a general purpose public figure. To that effect, there is little evidence that defendant himself is a public figure based solely on his social media engagement. Moreover, simply because plaintiff counts celebrity figures among his clients does not in turn make him a celebrity. Well, but when you do a reality TV show and have a YouTube channel centered around those celebrity clients, you might in fact be one. But either way, the limited purpose public figure argument, which I'm guessing they'll address in a moment, still may stand. And you have the really, really problematic issue of the cease and desist letter saying he is a public figure. Like that alone may be enough. That, even if he wasn't, that may be enough. Okay, to that effect, there's holding that evidence of awards does not make a person one of notoriety. Yeah, just awards don't do it, but that's not, he's not. What are these citations? No one is saying he got an award for being a tattoo artist, therefore he's a public figure. Like that's not the claim at all. In fact, defendant's exhibits show that plaintiff's Instagram profile, which has over 1 million followers, is really advertising for his work as a tattoo artist. This isn't helping. This isn't helping at all. The majority of the photos posted to the account show examples of tattoos that plaintiff has given to clients, ostensibly to encourage Instagram users to employ plaintiff to give them a tattoo. That's not a good argument. Oh my God. That's saying, look, he's got 1 million people that he's trying to the average tattoo shop's audience is not 1 million. It's 10,000. 50,000 in a major metro area with a high profile shop. 1 million people. It's a massive pool. If I had 1 million people watching my show, if I could tap into a 1 million man market, the amount of lulls I could have increases dramatically. Oh my God. Defendant also, I genuinely don't know if I'm a public figure and my YouTube account has 82,000 subscribers, right? There's no case law sufficiently establishing what number of subscribers constitutes a public figure. I might be enough because when you go back to when this law was established, 80,000 people's a lot. 1 million people is effectively everybody. Because when you think about 1 million back in 1976, and when you're paring down how many people didn't have TVs and eliminating children and counting each person as potentially 2 because of spouses, 1 million was huge ratings at the time of New York Times versus Sullivan. Absolutely huge amounts of people at the time. If you could get 1 million, it meant something different than it does today. But the law is based on then. Now, 1 million subscribers on YouTube, you may never watch their show and still hear about them because you got a kid or whatever. It's no one actually knows the answer. That's my point in this. No one actually knows where the law is. And to be brutally honest and fully clear, I do not think public figures should be treated different than private ones in defamation claims. I don't. I am on Romeo's side here legally and in theory, in that I don't think public figures should be treated differently because I don't see different standards being applied as an appropriate application of the 14th Amendment. I don't see it. That said, my theory is not how the law works. This is how the law is. So public figure status really, really matters right now. I don't think it should, but it does. And trying to go into a lawsuit and argue that it doesn't is... Defendant also argued that plaintiff's appearance on a reality show called Best Inc. confers public figure status upon plaintiff, but defendant's exhibit shows that plaintiff appeared on 8 episodes of the program 6 years ago. Defendant presents no evidence that plaintiff appeared on the show for an extended period of time. I mean, 8 episodes is an extended period of time. I want to point that out. That's not short. Had a major role, like, okay. Or that the program was widely viewed when it was on television half a decade ago. Simply put, defendant fails to establish a plaintiff as a public figure. And if that was the only argument, I might agree. But it's not the only argument. But again, I think he's a limited purpose public figure because he went on to do the interview. That alone is a problem. Even assuming the plaintiff is a public figure, a party's celebrity status on its own is not sufficient to render anything the party says or does subject to anti-SLAPP protection. In this case, the complained of statements refer to alleged private statements and actions regarding plaintiff's sexual preferences and proclivities. No, they don't. Actually, I will contend that if they're just talking about those 3, they don't refer to anything at all. They do not provide the proper context to the court. In fact, they specifically avoid the context with the court and are suing on those 3 statements in isolation. Really, really weird. They're now flipping the script and trying to have it both ways. Statements and actions regarding plaintiff's sexual preferences and proclivities. Oh, well, fuck me. Just go ahead and say it again in case the court didn't understand that your client wants to have sex with minors. Please say it more. Romeo Lacoste, by and through his counsel, Raul Saavedra, wants to bang chicks who are under 18, but y'all shouldn't care about it. That's the summary of this entire document. Clip it, love it, live it. Assuming that plaintiff is a public figure because he has many social media followers does not transmute his private sex life into an issue of public interest. Unless they're kids, man! What's wrong with you? In order to succeed in his motion to strike, defendant must make the... Hold on. I've got to make a tweet. I'm making a tweet right now. I don't do this too often on the show, but I've had a sufficient amount of whiskey. Just a second. You guys can check out my Twitter if you want. It's going up in one moment. There we go. Here. I'll snip the tweet for you guys so you can see what I just tweeted. I can't take this anymore. This is too stupid. Here we go. Here's the tweet. Assuming the plaintiff is a public figure because he has many social media followers does not transmute his private sex life, in brackets, sexual activity with minors, into an issue of public interest. Holy shit, Keemstar, does God just love you or does he hate Romeo Lacoste? So there you go. That's the tweet that I think summarizes this entire... It summarizes the entire document. It's amazing. In order to succeed in his motion to strike, defendant must make the threshold showing that plaintiff's claim involves, quote, conduct in furtherance of the exercise of the constitutional right of petition, constitutional right of free speech in connection with a public issue or an issue of public interest. Oh, do I have that thing on? Defendant's statements do not involve a public interest. The statements themselves are not reasonably related to any public interest. They seek only to harm plaintiff's business prospects and increase engagement with defendant's YouTube news channel. They are not protected by the anti-SLAPP statute. Therefore, this court need not consider whether plaintiff would succeed on the merits of his claims. However, defendant has also failed to prove that plaintiff has failed to state a claim for relief. I mean, maybe only because they were focused on the fact that you like to bang young chicks rather than the fact that you were suing them over 3 idiotic statements. The judge should excommunicate you and execute both of you. Oh my God. The parties, even if defendant's speech is protected, defendant cannot show the plaintiff has failed to state a claim. Parties agree that when an anti-SLAPP motion to strike challenges only the legal sufficiency of a claim, a district court should apply the federal rule of civil procedure 12b6 standard and consider whether a claim is properly stated. Here, defendant explicitly stated that its claim was one of legal sufficiency alone. Wait, what? Defendant explicitly stated that its claim was one of legal sufficiency alone, where a defendant alleges only legal sufficiency, quote, then the plaintiff can properly respond merely by showing sufficiency of pleadings. Okay, yeah. Show us the sufficiency of the pleadings, please. To satisfy the well-pleaded complaint rule, this is a federal rule. They're going with a line of cases. They're citing Ashcroft versus Iqbal, but it's the Iqbal-Twombly line of cases, and this goes back a long time. Ashcroft versus Iqbal being the most recent landmark case on the subject, and you learn this in first-year civil procedure in law school. You focus a lot on this because here it is. Basically, you have a duty when you file a complaint in federal court to give a succinct, brief description of the claim sufficient with sufficient specific pleaded facts that a defendant can understand what specific facts they need to respond to in order to have the suit progress. That's a summary of it. It's not the law school official summary, but it's a summary of Iqbal, Twombly line. It's Iqbal, Twombly, and Southwestern Bell, or whatever, Bell Communications. It's that line of cases, and it's the essential. You're giving not only notice of what you're suing for, but enough facts sufficient for a judge and a defendant to determine what specific acts you're suing for. It's a prima facie showing, basically. Okay. Pleading must contain a short and plain statement of the claim showing that the pleader is entitled to relief. The complaint must state a plausible claim for relief. They're citing Ashcroft versus Iqbal. Why are you citing this as Ashcroft? Everybody knows this case is Iqbal, you weirdo. When reviewing a motion to dismiss under Rule 12, the court... By the way, the reason that it's Iqbal and not Ashcroft is there is a whole bunch of cases versus what John Ashcroft was the Attorney General, right? Yeah, Attorney General of the United States. Do you know at all how many cases sued John Ashcroft as Attorney General of the United States? Like, all of them. During the time he was Attorney General, every case filed that involved the federal government in any way is cited as Ashcroft v. whatever. Whatever v. Ashcroft. It's Iqbal because there's really only one Iqbal. Maybe two. Oh, God. Cited as Iqbal, you idiot. When reviewing a motion to dismiss under Rule 12, the court merely looks at the sufficiency of the complaint. Court does not decide whether the plaintiff has a winning claim. Defendant argues that his claim is one of legal sufficiency to state a claim, but defendant attempts to litigate the merits of the case by stating that the statements in question are protected by the First Amendment. No, this isn't correct. Such arguments are inappropriate in this venue. No, they're not. They're not. You have to make a claim that shows why the otherwise protected speech is not protected in this instance. With more than mere conclusory allegations, like these are defamatory. That's a legal conclusion. That gets ignored. As they involve a determination of whether plaintiff's claim will ultimately succeed. No, they don't. They don't at all. Defendant argues that plaintiff's claims are barred by the First Amendment because the statements are not provable as false. Yes. Defendant argues that the complained of comments are merely defendant's opinion. Yes. Not only that they're merely defendant's opinion, but that they're legally unable to be anything other than the defendant's opinion. They're asking for a legal observation that they are not statements of fact, that they're only possible to be legally a matter of opinion. And the three statements that you cited cannot be factual claims. They are statements that are of an opinion. And you even allude multiple times that they're of an opinion based on related info. Even though that's not what you sued for, that's what you're arguing here. How on earth is a judge supposed to take those as statements of fact when you say that plaintiff believes that it's finished related to the sexual proclivities of plaintiff? Well, yes, that makes it an opinion, you dumbass. This inquiry goes directly to the merits of plaintiff's claim and is inappropriate at this juncture. No, it's not. It's not actually inappropriate at this juncture, and it's not actually about the merits of the claim. The merits of the claim are the defamatory fact statements. That's a merit question, is once you've established by law that they are statements of fact, then you have to determine the merits, whether they are false, whether they are defamatory, whether they cause damage, and whether they were made by a third party, or whether they were made about an identifiable party to someone else, whether they were published, and whether that damage can be redressed by a court. Those are the merits of the claim. Whether or not it's a fact or an opinion is a legal conclusion that needs to be made by the court at this point in time. Because if the court decides their opinions, there are no merits to have. They can't be litigated. If the court decides their facts, then you must litigate them. You must go on to say, okay, these are fact statements that are objectively knowable and therefore subject to a true-false test that we now need a finder of fact to come in and assist us, either a judge or a jury being the finder of fact. And they will weigh out the elements of the claim, and that will give the merits. Even if defendant's argument was cognizable at this point, it fails. Well, only because the plaintiff's argument doesn't exist. To determine whether a statement is one of fact, the court applies the following test. First, we look at the statement in its broad context, which includes the general tenor of the entire work, subject of the statements, the setting, and the format of the work. Next, we turn to the specific context and content of the statements, analyzing the extent of figurative or hyperbolic language use and the reasonable expectations of the audience in that particular situation. Finally, we inquire whether the statement itself is of sufficiency factual to be susceptible to being proven true or false. I hope, without reading further, I stop reading. I hope their argument is Romeo Lacoste is finished is a statement about the status of his ejaculate. And because defendant can because the plaintiff can objectively know whether or not he ejaculated while talking to the minor, that is a knowable, objective statement of fact and therefore is contestable. I hope that's the argument. That's the only thing that could make this fucking dumber than it is. Looking to the context of the statements, defendant's argument is contradicted by his own statement that Keem operates a popular YouTube news channel and that the channel features reporting on the news. Wait, no, it doesn't. Defendant's statements that plaintiff is a pedo, that his business should suffer and he should be incarcerated are not defendant's opinion alone, as they are advertised as news. Hey, you're not suing over this. I think they should hammer on this. You're not actually suing here. Therefore, defendant's audience would reasonably expect them and interpret them to be statements of fact, not opinion. Here's the problem, homie. even if they're statements of fact. You fucking admitted that they're true in your complaint and in this document. You said that the plaintiff's attraction to minors was not of public interest. That it's his private interest to be attracted to underage girls. Romeo Lacoste's lawyer said that it is in Romeo Lacoste's private interest to be attracted to minor females. Can I fucking say it again? It can't be said enough. Romeo Lacoste's lawyer said it is his private interest to be sexually attracted to underage women. If you're calling him a pedophile, that's the literal definition of pedophile. Pedophile, defined. A person who is sexually attracted to children. Well, fuck me. It's the goddamn definition from where? Where is this? This is just the Google dictionary. Merriam-Webster. Sexual perversion in which children are the preferred sexual object. Well, there you go. Pedophilia. As described by Merriam-Webster. Okay. Now, that's not even getting into the idiomatic use of pedophile. That's not even getting into the colloquial use or just derogatory use of pedo. Pedo being a subject, a summary of pedophile that actually has a different meaning from the DSM, pedophilia or pedophile. God damn it. And that his business should suffer, as he should be incarcerated, are not of defendant's opinion alone as they are advertised as news. Are they? Are they? And even if they are, you get to editorialize in the news as well. Therefore, defendant's audience would reasonably expect them and interpret them to be statements of fact. Hey, here's the thing. I'm not saying legally they're statements of fact, but these are factual. Romeo Lacoste is a pedophile. Gross. Bro, get help. Get off the internet. Delete all of your social messaging applications. All of them. Put a password restriction behind them. Get some sort of, I don't want to say a priest because there are too many jokes there. Get an accountability partner. You can't message anyone without somebody else putting in that. And if that somebody else isn't like an old wizened sage Samuel L. Jackson backhanding you and chaining you to a radiator like you're in Black Snake Moan, like if that's not the person who's in charge of your social media, I mean, just go find him. I don't have the appropriate joke. Find somebody to get control of you because you're disgusting and degenerate. Moreover, despite defendant's argument to the contrary, whether plaintiff is a pedo or pedophile is capable of being proven as true or false. But you've admitted that it's true. You admitted it. It's in the document. Admissions invalidate your defense that it's not true. Pedophilia is a psychiatric disorder which is defined by the DSM. Whether a person is a pedo is certainly capable of being true or false. It is not an opinion. That's right. That's right. And you admitted it's true because you're gross and weird. Defendant also argues that plaintiff has failed to state a plausible claim for relief because he has not alleged in a conclusory fashion the Keem statements or those of the girls were false or made by Keem with knowledge of their falsity or reckless disregard for the truth. Defendant is incorrect. In the complaint, plaintiff specifically avers defendant has a demonstrable history for making accusations, notably other accusations of pedophilia, which he is unable to substantiate, yet recklessly and maliciously continues to make such accusations. Hey, you dumb fucking old man. That doesn't say what you just said. That says that he has a history of doing so. What you have done is made a factual statement, but you have not actually linked his history of doing so to the present statements. You didn't do it. You didn't say, and he has done so here as well. You also can't just conclusively say recklessly and maliciously. That's a legal conclusion. Fucking read Iqbal, you idiot. It's in there because it cites Twombly, which was nothing but legal conclusions, which is why they threw it out. You have to understand that you've made a legally conclusory statement about other statements Keemstar made, not the instant statements of this case. But you don't, do you? Because you're probably dying of Alzheimer's. Plaintiff satisfies the pleading requirements. No, he doesn't. Oh my God. Because this court must only consider whether plaintiff has stated a plausible claim for relief, defendant's motion must be denied. Defendant's claim that plaintiff has failed to state a claim for TI with prospective economic advantage must be rejected. Defendant argues that plaintiff fails to state a claim for TI with prospective economic advantage because he's failed to show the defendant had knowledge and intent to interfere. Defendant relies on Piping Rock Partners, but in that case, the reason that the counter plaintiffs could not establish a claim for relief was because the counter defendant had stated in a declaration that the purpose of his statements was not to interfere with counter plaintiff's business interests, but to provide increased transparency and more information for investors. There's no such evidence here. Oh, Keem, you didn't say it in an affidavit, therefore it doesn't exist. Jesus Christ. This is so fucking stupid, I can't take it. Where plaintiff specifically affirms that by their unjustified and unprivileged conduct, as alleged above, defendant intended to disrupt plaintiff's prospective economic advantage, plaintiff has stated a valid unrebutted claim for relief. No, he hasn't. He stated a legal conclusion. Unjustified and unprivileged. These are legal conclusions. You haven't shown that they're unjustified or unprivileged, and you haven't alleged facts sufficient to support the legal conclusion. You've just conclusory stated that they're unjustified and unprivileged. Plaintiff has stated, additionally, defendant's arguments that plaintiff's complaint fails to state a claim is disingenuous. Defendant argues that plaintiff has failed to allege the existence of an economic relationship with a third party. Yes. Yes, that's kind of relevant to TI claims. But in defendant's exhibits, defendant explicitly states on his news program that he is aware that plaintiff has lost many clients. Yeah, that doesn't mean anything. Who are they? What economic relationship with what third party? Defendant also states, okay, that's how popular he was, but after the story came out with him trying to hook up with underage girls, his career is finished. Nobody wants to get a tattoo from this guy for obvious reasons. Where defendant publicly admits that his statements has interfered with plaintiff's prospective economic advantage. Nope, that's not actually an admission. This court should reject defendant's arguments that plaintiff has failed to state a claim. That's not actually an admission. God. Just merely stating that he has seen that it has occurred in this way doesn't communicate his intent. Defendant's unsupported claim that plaintiff cannot establish the elements of interference with contractual relations must be rejected. Defendant states that plaintiff fails to state a claim for interference with contractual relations. However, defendant does not state why he believes the plaintiff fails to state a claim. He merely recites elements of the torts. Well, fuck me. If he just recites the elements and says you didn't do them, that's why. Plaintiff satisfies the requirement of a well-pleaded complaint where he states that defendant was aware of and have knowledge of the plaintiff's contractual relationships with promoters, agencies, and social media platforms operating on local, national, and international stages. The defendants intend to disrupt the contractual relationships between plaintiffs and such entities. Again, intend to disrupt the contractual relationships. This is a legal conclusion. How did he do it? How did he intend to disrupt them? Did he contact them? Do you have any names of any contractual relationship? Even one. Even, that's all, guys, that's all it takes. Romeo Lacoste had an existing contractual relationship with Pizza Hut because Pizza Hut clients are fat, and therefore there's a lot of surface area for Romeo to tattoo. Seeing a mutually beneficial relationship, they had entered into a contract. Keemstar knew about his contract with Pizza Hut and called Pizza Hut to complain, or specifically tailored his message on Drama Alert to Pizza Hut, or knowingly provided a show on Drama Alert knowing that Pizza Hut's director of marketing and contracts was a avid viewer. Literally anything to connect anything. What at all? What video targeted your contract? What specific video? What line from the video? What contract? What person? Any detail. Guys, pleading standards in federal court are really, really low. Really, really low. Like, all you have to do is provide any fact. Date, time. The journalistic who, what, where, when, why, any of those things. Not even all of them. Any of them. And they got nothing in their complaint. What's up, Memology 101? Welcome to the channel, buddy. Oh, God. And as outlined above, defendant has long known that his reporting has had a deleterious effect on plaintiff's business and ability to retain his clientele. No, he doesn't know. He doesn't know that at all. You haven't established that he knows that in your complaint. Because defendant makes a conclusory statement with no factual allegation, well, pot, meat, fucking kettle, his argument that plaintiff has failed to state a claim for interference with contractual relations fails. Oh my God. Guys, this is really terrible. Imagine you're a lawyer. Some guy comes in. Now, let's do some empathy. Let's do some empathy here. You're a lawyer. Guy comes in. Tattooed weirdo. Right? Let's pull him up. I imagine he says Brett a lot. I don't know if that's true. Open tab. I imagine he says breh more than is socially acceptable. Okay? You are a 150-year-old lawyer sitting in your office, changing your colostomy bag. That thing walks into your office and says, bruh, like this dude, like Keemstar or whatever, he is ruining my business, bruh. And I lost a lot of money. I was really like pretty much a big deal, kind of famous and stuff. And like he said I'm a pedophile and whatnot, and it hurt. And I don't know what I'm gonna do. I had to lay off staff. Other staff all quit. I'm grabbing my staff, but it's not helping because there's no young chicks around, and I need help. I need help. And you are Raul Severo, right? And you're like, listen, bruh, how do you come to me on the day of my Parkinson's treatment and ask me to do this thing that I cannot, you know I cannot do? So you write up your complaint. And you say, look, I know that my client is a pedophile. But being a pedophile has really hurt his business ever since Keemstar called him a pedophile. That's been really bad. Like I gotta get that off the screen. someone is coming to you and putting their life in your hands, the life of his business. Please protect me from Keemstar. He's on the interwebs calling me a pedophile. Help me, God, please, anybody. I prayed all night and he said, call Raul Severo. And I'm not even a Christian or whatever, but I heard it clear as day. And so I'm going to get baptized. And then I come to you. And then, please help me. And he says, look, my client's a pedo. We need to understand that my client's a pedo. But someone calling him a pedo has ruined his life. Oh my God. Listen, and that's why you go to Sunday school. That's why you go to Sunday school and Bible camp as a kid. Because otherwise God will hate you. Like he hates Romeo Lacoste. Because God has to hate Romeo Lacoste. There's no other way that his life can be this much of a fucking disaster. It can't have gone worse for him yet. The only way it gets worse for Romeo is if he actually loses and then gets a slapback case from Keemstar and loses that. His life only gets better if those aren't the outcomes, and those are the most likely outcomes. I have to stress that. The most likely outcome for Romeo is not only did his lawyer tell the world that he's a pedophile, but then he loses the lawsuit and has to pay Keemstar. There's no redemption arc for this guy. He's just losing. Like Job, but less charming. Yeah, and it gets way worse if the DA comes after him. Thank you, David Smith. It gets way worse if they ask the judge, hey, please take judicial notice that he did all of these things and we would like to refer him. We'd like to go ahead and refer him to a district attorney to determine if sending sexually explicit images across state lines to a girl of 15 years of age might be a crime. Knowingly doing it. We want to refer him to a federal attorney in the Central District of California to determine if whether sending a penis picture to a minor child in Florida might be a crime through an internet telecommunication device. Oh my God! That's the only way his life gets worse than it is. Whew. I don't know what else to say, guys. This case continues to get stupider. Hats off to Keemstar, man. I'm sorry that you have to defend this and pay money. I know you and your lawyers are probably laughing at it. I hope you get your fees paid by Romeo. And I hope California has good collection laws. I think they actually do. You're lucky that he's in not Texas, for example. I hope you got it, because this is ridiculous. Especially based on what he appears to be suing on, which is the dumbest thing I've ever seen. Raul Severo. Yeah, he needs to be disbarred and in a cage. Look, I'll just state my opinion, man, that he needs to be in a cage. He needs to be arrested and jailed for his bad lawyering and his representation of Romeo Lacoste. Romeo also needs to be in a cage as well. Look, I'm joining in. I'm fully committed. I'm committed to saying that Romeo Lacoste is a pedophile who is finished and needs to be caged. All of those things. And the only reason I think that is because he literally said those things in court. He said that he's a pedophile, right? That he's having sexually explicit conversations with women he found out to be minors. He said on an interview that he knew that they were not 18 at the time. He said in direct messages to them, messages indicating that they didn't need to wait until they became 18. So that's my establishment for him being a pedophile. It's only his own fucking words and his statements in sworn pleadings. But the next thing is that he's finished. Well, he said also in his pleadings that he has lost a mass of clients. Now, since he does tattoos for celebrities who are presumably thin, unless one of the clients is Lizzo and that's the only client that left, I will assume mass means multiple rather than just one large client. Okay, so I will say he is finished. Also, being a pedophile publicly is a death knell for most businesses and should be. And then belongs in a cage. Yeah, I believe that is a factual statement based on the fact that he is a pedophile, sent his penis to an underage girl, knowing she was an underage girl in Florida, and then admitted to all of that in a court document, and that he should be referred to the district attorney and go ahead and put him in jail for literally ever. I don't care. He's a predator who is gross and disgusting and a danger to any girl with a cell phone. Get rid of him. There you go. That's my opinion on the matter. Also, factual statements. I'm full in. I dare you to sue me, you moron. You know, good luck. Good luck. Oh. Okay. All right. That said, let's wrap up with some super chats, and then we'll call it a night. And we'll call it a night. I can't believe this case exists. I can't believe it. Okay. John W. says, Nick, helping as many indie artists grow between now and the eventual mainstream entertainment crash is how we win. My animation channel is channel 7111, the word 1. So numbers 711 and then the word 1. Give me some love. So it's channel, the number 711, and then the word 1. 0 O-N-E. Oh my God. Channel 7111. Go check him out. See if you like his content. If you do, subscribe to it. There you go. TLJ Screwjob says, this is why I asked you and Mr. Peacock about knowing your client was guilty and trying to find a way to get them busted. Why else would this Raul lawyer be doing this way? No, if he did that, though, he would risk disbarment and all sorts of sanctions. That would be a terrible choice for him. Now, maybe he's dying and he wants to do that with his life. I don't think so, though. What's up, Inver? Welcome to the show. You have missed a disaster of a pleading. Or not a pleading, a motion opposition. Now, let me just real quickly state that what we've just read is the opposition, which is not yet properly before the court. In fact, the court has every right to deny the acceptance of this opposition to the motion. I think the court is going to accept it because courts tend to want justice to be served, and it's best served by addressing it on the merits, even if those merits are a pretrial motion to dismiss, rather than a procedural form error in the documents. That being said, we'll see. I don't know. If you would have asked me if the judge was going to strike the other documents, even telling me that they were deficient in the specific ways that they were deficient, I would have said, man, I don't think so. But because a lot of judges won't. They'll just ignore it. They'll go, I can read this. It's fine. This judge didn't do that. He wasn't playing. And he may just say, look, I don't believe your email excuse. Put some proof for it. Or, no, you're done. So we'll see. We'll see. Okay. Andrew War Snowboard says, just booked my hotel for Matsuri. I am hyped. Hey, man. That's awesome. I'll see you there. I can't wait. Cole Kiddo says, Nikki Bravo. Check the pics. Yeah, my hair is up today. Sorry. Siren Jag says, should have hired Big Chungus. Big Chingus. Yes, I agree. Stars Girl Forever says, your chat is the best. Hey, thank you. They're being very sweet to me tonight. P.S. Nick, your bangs are so high. 90s girls are jealous of you. Listen. They can only go higher. Look at this. I could have put them straight up like Carmen Electra with semen in her hair. Not Carmen Electra. What's her name? Cameron Diaz with semen in her hair. Garble Master says, first time super chat. Hey, thank you, buddy. Now that the Wisconsin Supreme Court rejected the stay-at-home order extension, many of the counties have imposed their own versions. What would be the legality of this and repercussions? I don't know. I guess it depends on what authority they actually have to do it. And I'm not familiar enough with Wisconsin law to know that. Cornholio174 says, what is the chance that Romeo could go to jail for admitting to the actions he has done? Seems like he's shooting himself in the foot for doing that. I think they're unlikely. It's possible. At this point, it's possible, but it's unlikely. Michael Ziada says, this case highlights this. As a lawyer, how do you reconcile dirtbag clients while being a good lawyer? You do a better job than this. You don't call your client a pedophile who's sexually attracted to minors several times in your filings. You just don't do that. That's terrible. You give them the best case that they can get. Really, and maybe Raul did this. He probably should have advised him, don't sue. Don't sue. But, I mean, it started, look at how bad, it starts at the cease and desist letter. Here's where the bad lawyering starts. When he admits that Mr. Lacoste is a public figure in the cease and desist letter, he's already done a disservice to his client. Not a malicious one, just a bad mistake. The bad lawyering started long before the suit was filed. So, I don't know what else to tell you. C. Collins, 68 says, have we considered that this lawyer is playing galactic 4D chess by attempting to send a pedo to jail via willful incompetence? No, we haven't considered that because lawyers don't do that. And if they do that, they get disbarred and potentially fined very large amounts of money. If it wasn't for this suit, Romeo might have actually got away with this. Yeah, he might have. He could have maybe repaired his reputation. I don't know. He could have just stuck by a standard denial. He didn't do that. But he screwed that up last year when he went on Keem's show and admitted to everything. What an idiot. Kidda says, why do I think Moron and Law Twitter are going to claim you just made the case that Kick Vic was right all along? Public interest argument. I have said for a long time that I think Vic very well may lose as a limited purpose public figure. I think so. I don't think that makes their statements, which I do believe to be statements of fact that are made with malice and reckless disregard, knowledge of the falsity or reckless disregard for the truth. I think that is still true. I think that's still correct. But I think Vic loses the public figure argument as a limited purpose public figure because of his statements to IO9 and his statements on social media and in his Discord, which I have said multiple times he should not have done. He should not have done. I'm not his lawyer. I wasn't his lawyer, and I couldn't advise him to make or not make those statements. Okay, so those exist. I don't think it's a foregone conclusion that he's a public figure, but I think that's a tough argument, and I've said that many, many times. And the only reason anyone in KickVic or Law Twitter would claim otherwise is because they don't actually pay attention when they watch my show. But let's see. Alex says, hi from the nanny state known as England. These streams have helped the time lockdown pass with ease. Keep up the great work. Hey, thanks, buddy. Thanks for tuning in. Nathan Pudrir says, are you going to do a future live stream or response video to the interview Ron Soye did? Probably. I wasn't really, but I'm getting a lot of requests about it. Weirdo with a Cello says, off topic and maybe asked already, but you said last stream classic Star Trek couldn't be made today. I agree, but want to know your reasoning. Also, Mignana is a better Kirk than Pine. Classic Star Trek couldn't be made today because of all of the sexual innuendo and the way they portray women. Period. That's it. There's nothing else that needs to be said. Kirk's a dog, man. He's a dog with women. And while in the real world, people are, just deal with that. Like, oh, that guy's a dog or that guy's not a dog. That's fine. It's just how some guys interact. In the world of popular media, that is no longer acceptable. We have to pretend that there are no dogs, no dog males that are not like in jail or being murdered as we speak, or hit with bike locks or whatever. Alex upgraded to super lawyer. Thank you so much. And Benjamin Myers also joined as a paralegal and then upgraded to lawyer. Alex, make sure you check out the super lawyer exclusive community post to find out how to get access to the Discord. That's how you do it. Go to the community tab on Rekieta Law, find the super lawyer only post. I think you can filter it out, and that there's only one about joining the Discord, and it's there. Go to that. Cynic in Chief says, number one question, what will Keemstar do with a tattoo parlor? Good question. Alex says, relating to the other day's stream, can we all call Mr. Peacock Mr. Chingiscock instead? Yes. I say yes. Captain Kerfuffle says, help me, Mr. Peacock. You're my only hope. Nick Rekieta 2020. DCV Titan says, Peacock, don't dive in front of the bullet after you've already dodged it. Simp move. Zero Foxity says, I think Romeo's lawyer discreetly wants to get him ruined. Kekwa. Okay. Matt Schrodinger says, don't call my pedo client a pedo. That's illegal. Ash Ukihime says, bangs door hard. FBI, open up. Breaks down door. Yes. Memology, again, welcome to the channel. Prime Time Durkheim TV says, have you considered fighting games? I have considered them. I don't know what else to say. Nix Hex says, Vic case is the most ridiculous. LOL suit is the funniest. Is this the stupidest? Yes. So far, this is the stupidest case I've seen. The LOL suit was really stupid too, though. I don't think we can underestimate how stupid the LOL suit was. This one is, maybe this is the most sad, maybe this is the saddest. Because this is a lawyer just ruining his client. Hey, Kai, Suzugamori says, just wanted to say I love your videos. Wish you and your family the best, man. Hey, thanks, buddy. I appreciate that. I wish you the best as well. Leo Breaker 49 says, evening, Nick. Hey, evening. Just wanted to send you a little bit of love since I'm behind on the last few shows and just got here. Hope you and yours are doing well. We are doing very well. Thank you so much. And Nick Naylor has upgraded to super lawyer status. Thank you so much, buddy. And again, I reiterate the same things about the community tab and finding that post. All right, guys. This is what I've got for you today. Thank you so much for joining me and my tall pompadour hair or whatever is happening up here. It's ridiculous. It gets more and more ridiculous as the day goes on. I can't wait to get a haircut. Oh my God, I want a haircut. You know, if you like this video, share it or whatever. But really, I did a short update on this on earlier today. And I think the best videos to share with people are the short ones. Live streams are hard to share with people. So if you guys would do me a favor and share those around when they come out, I'm going to try and get one out tomorrow as well. Otherwise, but other than that, thank you all for watching as always. Austin Heartless says, lost access to the Discord. Can you DM or email me or whatever? I don't know the circumstances of that. So please DM me or email me at rekieta.org. Just let me know what's going on and we'll figure it out. All right, guys. Thanks for hanging out with me tonight. I will be on Twitch in just a little bit. I got to get some food. If I don't get some food, I'm going to die. So I'll be on Twitch in a little bit, though. Thanks for hanging out. Have a good night. Peace. Peace.